Weekly list old matter item number 1.
Give me part of my land, infractors.
Infractors disposed of. All right. Right.
Weekly list old matter item number 2.
I am appearing for the Union of India matter.
All right. None appears dismissed. Number.
Weekly list item number 3.
May I please? The petitioner, I challenge the which guarantor which has been done in impersonation and why a fake loan has been sanctioned in favor of the opposite party not to. And in view of this order of this Honorable High Court, the crime bench has been investigated the matter and the report is there. That has been clarified that there has been impersonation and he is not the guarantor at all. And the
Which order, sir?
matter the report is
Oh, no. Which order notes all this?
orders, my lord, the substitution application, the person, the petitioner, sole petitioner has expired. I have filed the substitution application that is 1837397 of 2011. Substitution application has been filed.
No. Last time, 23rd July 2021. Please read the order. You don't have the order. 23rd July 2021 order.
Yes, my lord.
You don't have a copy, sir.
No, I have not.
All right. We'll give you the copy. We'll give you, sir.
I may be
We are here only to help you.
I'm
1 minute.
appealing for the opposite party bank, my lord. I can read out the order if
No. Our learned friend has to read the order, sir.
yes, my lord.
Only in this court, sir, lawyers don't have orders in their own matters.
Sorry.
That seems to be the pattern here. Kindly read it, sir. Read it aloud. Kindly read it aloud, sir. Kindly read it aloud.
This application is taken off by video conferencing mode. Since the criminal case is pending before the court in which question of a fraud is to be adjudicated, we think it proper to await the decision of the criminal proceeding. This matter on 27
So what happened after that?
My lord, in view of the crime branch investigation, the criminal proceeding is pending against the bank officers and the persons who was involved in the impersonation.
No. So what happened in the criminal proceedings?
My
Is that
lord,
come to an end? Where is it pending?
The present status is not moving. That was directed to government to take instruction. What is the present status?
The 7 accused were there. 1 accused is on bail. Trial has commenced. So I'll take the present position of the trial if my lords call this matter next week.
No,
Exact
but
position.
why should all this wait for that? I'm not able to understand. Why don't we close this and ask this to be revived if that we'll stay the entire thing, whichever stay order we have passed.
My lord.
Let it continue till the conclusion of the criminal proceedings.
My
And then
lord.
depending on the outcome of the criminal proceedings, let the bank take fresh steps.
My lord.
I may be pardoned because the DRT proceedings have been stayed since 2011.
Correct. So they can revive. We'll permit the DRT to revive after the conclusion of the criminal proceedings.
Obliged.
My lord. My
You
lord.
see, the criminal proceedings are still set to be pending. This court has already, by an order dated 17th May 2011, stayed the proceedings in the Debt Recovery Tribunal in OA number 349 of 2009. And that stay order has continued for more than 11 years now. Instead of waiting endlessly for the conclusion of the criminal proceedings, the court considers it appropriate to dispose of the present writ petition by making the aforementioned interim order continue till the conclusion of the criminal proceedings, after which, depending on the outcome of those criminal proceedings, the proceedings in the DRT will revive vis-a-vis the present petition. The petitions are disposed of in the above. The one petition or two?
I am one petition.
Sorry?
Petition number 1.
I'm for the bank in all the
That
three
is
cases.
another
Petitions
petitioner who is he also the guarantor.
Correct. So 3 petitions.
Two
All three
petitions have been filed.
Yeah. 3 petitions have been filed.
I am for the petition in the case number 12889.
All right. Petitions are disposed of. All right.
I'm for the bank in all the cases. May not my presence by kindly record.
All right.
Obliged.
List item number 4. Item number 4.
Lordship, I am appearing for opposite party.
All right, none appeals for the petitioner dismissed or not.
Weekly list item number 5.
Lordship, item number 5 to 10 on behalf of DS Das, no instructions.
No instructions. 5 to 10.
Dismissed.
Weekly list item number 11.
11 infructuous, Lordship.
Infructuous.
My name is written for university, Lordship.
All right.
Weekly list item number 12.
None appeals dismissed or not.
Weekly list item number 13.
None appeals dismissed or not.
Weekly list item number 14.
None appeals dismissed or not.
Weekly list item number 15.
15, my lord, there is, along with this, there is another PIL matter in which an order has been passed. The order has been challenged before the Honorable Apex Court. That matter may become along with it, that is WPC number 31946 of 2011. The challenge to the collection of toll.
Collection of toll.
Yes,
Yes, my lord.
Hmm.
I am for OP number 6, my lord.
Right.
This is regarding collection of toll, my lord. And the other writ application was a PIL where they challenged the entire notification. The issue in this writ application is confined to the petitioner, saying that on the basis of a 2005 circular, I should be allowed for a concessional rate of rupees 1,000 per month per bus and not more than that. This was their prayer, and the interim order was passed in this case on the basis of that
This
31946.
is only for this college, is it?
Yes, my lord.
This is
Only
For
for this
these
college.
college buses, that
Yes.
concessional rate.
Yes,
applies.
yes, ma'am.
Yes, my lord.
Why? What is the basis, sir?
So that is that circular. That circular.
Where is that circular? Show us.
One.
No. So these during the period of stay, their buses have been going without paying any toll.
No, my lord. 1,000.
1,000 rupees
One-
since then, my lord. On the
So
basis,
so you have not suffered any great loss because of that.
no, my lord, we have
challenged
suffered.
it before the Honorable Apex Court, and in both the matter, no stay was granted. And
But the-
ultimately, that civil appeal has been dismissed.
No. Ultimately, the interim order in the main case was kept in abeyance, and the
Yes.
matter was targeted by the Honorable Supreme Court for being heard by this Honorable Court, my lord.
Kept in abeyance meaning what? They're paying the full
Well,
toll now.
No, my lord, they are not paying.
So it's not kept in abeyance,
Yes.
sir. That interim order has been confirmed by the Supreme Court.
It has been kept in abeyance, my lord. Order is kept in abeyance, my lord.
Sir, how can, if they're not paying the full fee, how can that stay order be kept in abeyance? It's
Ma'am,
obviously in operation.
My lord,
With permission, may I just say, my lord, what happened here that the two in the 624, the present rate application, the interim order dated 9/5/2012 was assailed before the Honorable Apex Court in two SLPs. One by the National Highway Authority of India, the other one is by the company. Now, though previously the other order was passed and these matters were directed to be tagged, but the Honorable Apex Court says no stay. And then I'm handing over the order, my lord.
That's four. There is no stay of the stay.
Of this
Stay.
stay.
So
So,
which means the stay
ac-
continues.
Accordingly, the stay continues.
I don't know why he's saying it's an abeyance and abeyance.
And ultimately,
What does that mean?
Initial, and this is the final order passed, my lord. I'm just handing.
In fact, it specifically say no stay.
No stay,
Ah,
my lord. I'm handing over this order
main
ultimately.
writ application.
sir, in the SLP,
My
there
lord.
is no stay.
My lord,
What you are challenged in the SLP was the stay order.
my lord.
If there is no stay of stay, what is the meaning?
My lord, the stay order in this, my lord, in this writ application was based upon the interim order passed in 31946 of 2011.
Whatever, sir. Which
Yes,
means
ma'am.
there is a stay order
My lord,
which is continuing.
my lord, in this,
Ah.
yes,
You keep on saying it's an abeyance, it's an abeyance.
my lord, the main order is kept in abeyance. That is, I'm sorry, my lord.
You're still repeating the
My-
same thing, sir.
No, my lord, in this writ application, there is no stay.
All right.
So in terms of the interim order, if your lordship dispose of, I have.
No, my lord, your lordship may tag up
They have not
319.
filed,
What
they
has
have not
happened?
filed any counter.
I have filed counter.
They have
Counter
not
is there.
filed counter in this
Counter
counter.
is there, my lord.
Preliminary counter affidavit is there.
Yes, my lord. That
The-
answers
the-
every
the-
aspect.
A National Highway Authority.
Yes, I have also filed a
I
counter.
have also filed, my lord.
Alert.
I didn't have the copy, my lord. It is not served on.
No, what is the ground? You say the circular applies to you, and they say it does not apply to you.
That's it.
That's it, my lord. My
So let's read the circular and be done with it, sir. Whatever order we pass here will apply in the PIL also.
Before that, my lord, I will only place certain facts which has changed since the filing of the writ application, my lord. This toll plaza that they are talking of was at Mongoli. That has now changed and shifted to Bondalo 15 kilometers away.
Oh.
And they
Yes,
are challenging one notification of 2011, the toll fee notification of 2011, which has also changed since there is a revision every year. So there is a new notification now, my lord. So notification doesn't.
My lord, now the cause of action doesn't survive, my lord.
No, my lord, it is survived. First of all, this
because
my lord, 15 kilometers. They just allowed it.
Toll plaza which was there in Mangoli, that has been shifted to Bandalo, and the toll plaza which was shifted there in my lord, Panikoili, that has been shifted to some other places, my lord. Now their buses will not cross that toll plaza.
No, my lord, that is not correct. I am for the petitioner, right? My lord, this has shifted barely 3 kilometers at the place where it is notified in the agreement. That was one of the ground here challenge, that in the agreement there is a notified place, and initially they have not set up at that place. That is one of the grounds. So it has shifted to that place. Again, that is within 3 kilometers of the institution, within more less than 3 kilometers of the institution, and the institution bus is passing that toll plaza, which is the subject matter. So
you file an affidavit about the change.
Yes, madam.
Or counsel to petitioners. Opposite party number 6 says that as well as the NHAI.
Yes, madam.
State that the factual situation has changed since the filing of the petition, and therefore this petition has become infructuous.
Yes.
Both of them agreed to undertake to file affidavits in this regard within 2 weeks with an advance copy to counsel the petitioner, who is permitted to file a response thereto before the next date. Interim order to continue. List on
The other writ application may be tagged, my lord.
1 minute. 29th November.
Along with 31946, I think.
31946
of 2011.
All right.
Weekly list item number 16.
My lord, on the behalf of Pavitra Naik, due to some personal difficulties, my lord can take it next week.
No, tell us what the matter is, sir.
Today morning, my lord, senior give me the file.
Just tell us what the case is about. There is no stay, nothing. This has become infructuous, I think. Who's for the department?
Yes, I'm appearing on the behalf of the department.
Tell us, is it still alive or it's over?
It is over. It is over.
No, the cause of action is still alive.
No.
There is no stay in this order. In this petition, there is absolutely no stay, sir. He said the challenge the present petition was to a circular dated 10 November 2008 regarding computation of value under Section 14 of the Customs Act for levy of export duty. There has been no stay of the said circular during the 10 years of pendency of the present petition. Full stop. Clearly, the subject matter of the petition has become infructuous and the petition is disposed of as such.
Weekly list item number 17. Item 17.
None appears dismissed from non-prosecution.
Weekly list item 18.
None appears dismissed from non-prosecution.
Weekly list item 19.
Item 19 kindly pass over, madam.
All right.
Weekly list item number 20.
Lordship, item 20, there is no instruction in this matter.
No instruction is disposed of.
Weekly list item 21.
21, my lord, also no instruction.
No instruction is disposed of.
Weekly list item 22.
May I please, my lords?
Yes.
But this is one the case where the question arises for lordship's consideration is whether Millard's raw BD, which is dealt by this petitioner, comes under tobacco or tobacco products under entry 16 of the Schedule 1 of the Orissa Entry Tax Act. The precise question.
We've given a judgment the other day.
Your lordship has decided.
I know that I have given a copy of your lordship judgment.
Okay.
Your lordship, Millards, has dealt in referring to entry 16 BD Millards. Your lordship have not dealt in raw BD Millards. Millards, raw BD, as per Millards, I have given a judgment of Honorable Karnataka High Court, which relies upon refers to Millards 3 Supreme Court judgments, Millards. Your lordship is correct in that judgment, because I am not in quarrel over that, Millards. Your lordship rightly decided. But Honorable Karnataka High Court, referring to 3 Supreme Court judgments, said that raw BD is not tobacco product and raw BD is distinctly different from BD Millards. That is what I want to Millards impress upon lordship. My lords may kindly see Millards, the judgment of Honorable Karnataka High Court, which is there in serial number 5. I have annexed to the compilation, Millards. Subhasini products. My friend probably doesn't know what BD is, but I am sorry to say. You do not know. Fortunately, unfortunately, I have some spark to know. Anyway.
In your lordship also, your lordship might have remembered, in that case also, Learned Tribunal has allowed the case by cognizing the Karnataka High Court judgment. Your lordship.
We are not on that. Because your lordship may kindly see judgment, Millards, page 212. One paragraph, your lordship may kindly see what it is, Millards. Let me place you one paragraph. The raw BDs are totally unfit for smoking or human consumption. Before rolling, the BD leaves are necessary to be soaked or sprinkled with water and got piled up and covered by a fully soaked cloth or gunny. It is done so in order to soften and mellow the lips and make them flexible and fit for rolling, and otherwise the lips are likely to broken while rolling. The tobacco is thereafter stressed on the soaked BD lips and rolled and yarn twisted and of tapering, and when they are so rolled and yarn twisted, they become raw BDs. And these raw BDs simply rolled on yarn twisted as stated above, enter the local area from outside or received from within local area are contractors. These raw BDs at the time of entry in local area from outside and even thereafter remain wet raw BDs are unfit for human consumption and susceptible for formation of fungus therein, unless they are heated in our heat chamber within 24 hours of rolling, as otherwise due to moisture content of the lips, the tobacco content therein would be spoiled. It's a health hazard to smoke raw BDs before heating, and nobody consumes or smokes the raw BDs. A most significant aspect to be noted in this behalf is that the raw BDs are not at all marketed. Raw BDs are not available in the market.
How far is it true? Then why are you in the court, sir? If it is not available in the market for sale or purchase, you should not be in the court at all.
No, those are intermediary goods, Millards.
No. You're buying this, which is why they are asking you to pay. What is this? What is the tax here?
I am buying raw BDs.
It's entry tax.
Entry tax.
So if you're buying, then this line that it is not available for sale or purchase is not correct. You're obviously buying.
No. What the facts said shows that raw BDs are not fit for human consumption.
No. Not being fit is one thing, sir.
My lords.
You're buying a product.
My lords.
It's an identifiable product.
Absolutely.
Suppose he gives you ordinary neem leaves. You will not buy it. You will say, no, I want raw BD. You identify the product. It's a marketable product, which is why you're saying, is it good enough for me to use? So I'm buying it from you.
The question is,
just 1 minute, sir. I'm already subjecting him to some questions. Sorry. Yes.
So only thing is that Honorable High Court has referred to so many things, including that Burma Cells case, Tata Loco Burma Cells, where the very entry 52 of the Constitution, entry 52 says entry of goods into a local area for use, consumption, and sale.
Correct.
So that
the minute you buy, there is a sale, sir. He's selling it to you. So there is a purchase and you are purchasing it, he's selling it.
So in the similar fashion, these are brought in from outside the local area.
Correct.
And against the order passed, this was challenged before the High Court, and here also this has been accepted initially twice. All the orders have given, but for this period, aberration has taken place, and they have subject levy of tax. Your Lordship, if you proceed further,
yes,
proceed further.
Yes,
Your Lordship will see the question primary is.
Yes,
I think if Your Lordship permit me the previous paragraph also,
all right.
We think The assessing authority erred in the observation when he says raw BDs are smoked by a few. He has page 214 minutes, 214, sorry.
Right.
We think the assessing authority erred in the observation when he says raw BDs are smoked by a few. He has mistaken the raw BDs as khula BDs. Raw BDs are not marketed at all.
This is where is the problem, sir. How can we say it's not marketed? You're buying it. If you're purchasing it, where's supposed to be not being marketed?
Yes, not for consumption.
No,
further production.
not marketed. In fact, it's a very significant statement. Some product, when it's being bought and sold, how can we say it's not marketed?
To that extent, there may be a second view. Then you will also kindly see. The question primary is whether a raw BD is a BD for the purpose of entry 2 of the schedule of the Act. Petitioner seriously denied the claim of revenue that reference to the word BD in the entry would include all forms of a BD, such as a raw BD. Whereas entry 2 is rather more beneficial so far as entry 16 is concerned. If you will consider vis-a-vis schedule 2. Schedule 2 says, that is also referred to, that is in page, in schedule 2. It is schedule 2, yes, it is there in 215. A few other contentions are required to be considered now. Mr. Inder Kumar's first contention based on considered goods. Since section 3 of the Act levies tax on the entry of the scheduled goods, it was contended that thing which is not goods would not be subject of the levy. Alternatively, the council contended item 2 of the scheduled act enumerates. Item schedule 2 you can see. Tobacco products like BDs, etc. This is more rather close to our entry 16 minutes. Tobacco products like BDs. And therefore, if a thing is not a product at all, it cannot be a tobacco product. In other words, a thing which has undergone a full process of production can be called as a product and not as a semi-finished thing or an article. Several instances were, because now Union Carbide case was referred to and elaborately discussed, and how Honorable Apex Court has said and what light and manner your Lordship will find below. In Union Carbide case, Supreme Court held that to attract excise to the article manufacturer must be capable of sale to a consumer, and that it should something which can ordinarily come to a market to be brought and sold. The Law and Council highlighted a stage of production at which raw BD is obtained in the process of manufacturing the ultimate finished product, popularly referred to as BD. According to the government advocate, the meaning of goods is very wide and has to be understood in the context of entry 52 list 2, 7th schedule. Since the Act levies tax on entry of goods, as per Article 366(12), goods include all materials, commodity articles. Definition of goods, 270 Sale of Goods Act, goods means every kind of movable property other than actionable claims of money. And includes stock and sale, growing crop, grass, things attached to farming. Let me skip. The raw BD, sorry. The raw BD is a material, commodity or an article. Since it can be owned or prescribed, it cannot be denied that it's an article. It's an article. The word used in the legislative entry, like entry 52, are to be liberally and broadly understood so as not to restrict the scope of taxing for a state. The concept of goods under Central Excise Act was more restricted because it's a law traced to entry 84 of list 1, 7 schedule Constitution, wherever duty of excise and tobacco.
Excise law, you'll have intermediate products, you have final product.
Correct.
An aluminum can made for a torchlight is intermediate product. So obviously it's not a final product. So they say it's obviously not goods, therefore, for the purpose of the excise law. That's very different from entry tax. When you're actually buying the raw BD, there's the question of it not being marketable or identifiable as a commodity.
Question is whether raw BD is at all BD. These are two different things. If your Lordship will see entry 16,
yes,
that says tobacco and tobacco products.
Correct.
Tobacco. And raw BD specifically has been held by Honorable Karnataka High Court, referring to all these.
No, only Karnataka High Court, sir. No other High Court.
No other High Court.
You don't agree with Karnataka, sir.
Yes,
so we'll pass the order. We don't agree.
And one more point. I would like to canvass additional goods of special Goods of Special Importance Act 1957. That says our entry also says so. I have given to your Lordship other related
unmanufactured tobacco.
VAT Act, and also our other related entries under the Entry Tax Act also. 1631, 1357. If your Lordship will say this, if that is an explanation which I have stated, that is in the explanation 1/6/2007, dated 16/7/11, serial number 7. That says that if any goods like sugar, cotton, textile fabrics and tobacco, if that is subject to levy of additional goods of special importance act, additional duties of special importance, then state authority has no power to levy tax.
No.
Of course, that is sales tax. Sales tax. I do admit. Sales tax.
Yeah.
But this is entry tax, that is sales tax.
That's right.
Because state is the participant of Constituent Fund of India.
Correct.
So therefore, the Kothari product that is also dealt in.
Correct.
So my humble submission before Lordship will be, if your Lordship will not take into consideration all the relevant entries, 16, 31, 32, 50, some of the Entry Tax Act, and contemporaneous entries on the Orissa Value Added Tax Act,
Right.
Sales Tax Act, you will also find
Right.
that this BD doesn't specifically find place in the schedule, because the law is, unless it is enumerated in the schedule specifically, it cannot be brought to levy of tax.
So, but tobacco and tobacco products, sir.
Tobacco products. Because having said so, my lords will find that entry 31 speaks of cigarette and lighter. 32 says pan masala, other tobacco products, including jorda. Those are class of articles, lords.
Yes.
And this gudaku. So it could have well said BD also. There is no, if you
So
are
the whole range is covered, sir.
No.
Therefore, everything is 1%.
Miller's only one line, but tobacco products, the legislature could have stopped there. Miller's my humble, your lordship can Miller think of. Miller's, if tobacco covers everything, there is no need of Miller's prescribing entry 31, entry 32, entry 50. No required at all, Miller. So that is why legislature had in mind to whom to tax and what not to be taxed.
Correct.
I leave it to your lordship's judicial consent.
All right. Petition is dismissed. We'll pass the detailed order. Petition is dismissed. All right. Interim order is vacated.
Weekly list item number 23.
Item 23, I am there.
Yes.
But here, if not, only one question is there. If Annexure 2 has been received, then I have a case. If Annexure 2 has not been received, I don't have a case. Here, your lordship directed the record to be produced on 4/9/2017 to check whether the government has received such a letter or not. If they have received, they must have an entry to that effect.
No, they filed a counter, sir. So we'll know from that.
Yes, my lord. The counter has been filed denying that they have not received.
That's what.
I have filed a rejoinder also saying that no, it has been sent.
The original record is there, then we have not received. That is not.
The original record is there.
And yes.
It's not there, the original record, sir.
If it is not there, actually, I don't have a case in fact.
All right. You say the only doubt was whether Annexure 2, being a letter dated 26 July 1991, written by the petitioner to the Director of Estates.
About the change of address. That was about the change of address.
About the change of address had been received by the Director of Estates or not. While the petitioner asserted that it had, in the counter affidavit, it was denied. Paragraph. This court had directed the original record to be produced to ascertain if indeed the letter had been received. Full stop. The court has perused the original record and finds that there is no such letter in the record of the opposite parties. That view of the matter, the status quo order passed on 21st January 2013 is vacated. The writ petition is dismissed. No orders is to cause.
Weekly list item number 24.
May I please, your lordship? The petitioners here, my lord, challenge the order passed by the additional district magistrate Bhubaneswar, by virtue of which the lease.
What is the date of your purchase?
Purchase, my lord, 6th of 12/1982.
82.
So this, because you say on the short ground that the petitioner who has purchased the lot in question from the original lessor on 6th December 1982, that is much before the impugned order dated 24 July 1989 of the Additional District Magistrate Bhubaneswar (ADM) in revision case number 31 of 1989, was not issued notice prior to such order being passed, the impugned order is hereby set aside. Stop. Revision case number 31 of 1989 is restored to the file of the ADM Bhubaneswar and will be listed there on 26th September 2022, on which date the petitioner will appear along with a downloaded copy of this order. The ADM Bhubaneswar is requested to proceed in accordance with law and, after hearing the petitioner, pass a reasoned order disposing of the said WL case within a period of 4 months thereafter. till such time the status quo passed on this status quo order passed with this court on 15 March 2013 will continue. The petition is disposed of in the above terms.
Deeply obliged, Your Lordship.
Weekly list item 25.
The memo is taken on board. Permitted to withdraw the petition with liberty to file a fresh petition. Any cause of action survives.
Weekly list item 26.
None appears to sustain opposition.
Weekly list item number 27.
Not the management is the petitioner here. Management, in fact, is striving for an opportunity of hearing. That's all, my lord. An opportunity of hearing before passing an award by the labor court. The issue here, my lord, I'll tell you, lordship, the short background. On one particular date, 18/11/2011, the matter was posted and it was argued on an application filed the management to recall the witness. That's the date, my lord, to recall the witness.
There is no stay of the proceedings here.
Beg pardon?
There is no stay granted.
No, my lord, what has happened here? An ex parte award has been passed already. An ex parte award has been passed. And today, before your lordship, we are either to set aside the ex parte award or not.
No, but there is no stay.
Beg pardon?
There is no stay, sir, granted by this court.
No, there is no stay order, but then our award is not staring at us. The award which we are
still staring or staring at him?
Not him, Lord. We are for the management.
No. Why is it staring? It must be executed by now.
Lord, the award is reinstatement with full back wages. Because of this because of this application to set aside the award, we are challenging the award before your lordship.
No. Have you implemented the award or not? There is no stay of the award here.
Lord, we are challenging the award. Lord, there is no question of implementing the award.
Why? If there is no stay, you have to implement it.
Lord, we are challenging it before your lordship, Lord. It's a question.
Mr. Ratha, you filed this with an application for stay?
Here, Lord. Right.
No stay was granted?
No, Lord. It is not rejected also, Lord. I don't think my stay application has been rejected.
So if it is not rejected, it is granted.
Your lordship may kindly consider.
New thing I've been hearing now.
Lord, lordship may kindly consider. Implementation, Lord.
So there is no difference whether I grant a stay or don't grant a stay. For you, it is a stay anyway.
Lord, I don't, Lord, I am not, Lord, lordship may kindly consider, Lord. It's a question of implementation of award. He has to file an execution case. The workman has not yet filed an execution case for that. So it's not a question of we implementing the award. He has to file application to execute the award. He has not filed any application. Today, your lordship may kindly consider one.
Where is he? Where is he?
Beg pardon?
Where is he? Where is the workman?
The workman is not appearing, Lord. In fact, I was directed to serve a copy on 22nd of February 2013. To serve a copy on the counsel appearing in the connected matter. I have served a copy on him. Lord, I don't think they are appearing.
Reflected. No, that counsel is now there. Yeah.
In fact, this honorable court, the judgment I have annexed has already held that the judgment is ex parte judgment. The award is ex parte award. That is settled. That is already held between the parties, my lord.
What's the age of the workman now?
Lord, age of the workman.
You're not going to decide all this academically.
Lord, because if he executes the award, complete full back wages. Lord, may kindly see page 48, my lord. Reinstatement with full back wages, man.
So you've given yourself a stay. So you've not had to pay anything for how many years now? 11 years?
Lord, he is not entitled to be reinstated. That's a matter on merits. Your lordship will consider
All
that.
That is fine, sir. You have not implemented. That's the long and short of it.
Lord, it's not incumbent on my part to implement. Lord, he has to file execution case for that. No management will so much come forward to implement it, man. He has to come forward and execute it.
You know, in Delhi High Court, we never simply entertain petitions like this. We know the workmen will be left high and dry. In 90% of the cases, the workmen are left simply high and dry.
Lord,
here, what is worse is you have not got a stay and yet you have given yourself a stay. In Delhi, we would ask you to deposit the entire sum and ask him to withdraw 50% without any security.
Lord, I am not challenging the award here. Lord, one particular order I am challenging. Before this incident, before the passing of award, Lord, if your lordship would kindly see that one order only, lordship will be convinced.
So what has happened to the award? You have not challenged it at all.
Not at all.
So how is this maintainable also? Once an award is challenged, passed, and you have not challenged the award, then what remains?
Challenging award, your lordship knows. There are 4 methods of challenging an award or judgment. 1, 913, 2, appeal, 3, review, 4 by a separate application. Lord, this is a case 913 in the spirit of 913, challenging the award itself before the same tribunal. We are saying that
challenge is a recall, that's all.
No, it's not. It's an ex parte award that has been held by this honorable court. If you
This is
kindly
like-
see that
yeah,
judgment.
It's a 913. So anyway, which is dismissed. A 913 has been dismissed.
Milord, in fact, it was earlier dismissed. We came before this honorable court. It was dismissed on the ground that it's not an ex parte award. The tribunal held that it's not an ex parte award. Rejected my application. We came before this honorable court. This honorable court, after hearing the parties page 41, if your lordship would kindly see, my lord, this honorable court has held that it's an ex parte award and permitted us to raise this issue before the tribunal to get it set aside. Now, when he raised the issue that you have not given me, what happened here, my lord? On 18/11/2021, the matter was posted for argument on the basis on the petition to recall the witness. What the tribunal did is, my lord, heard the matter, reserved for orders on that petition. Then my lord, we do not know what happened. We are waiting for the orders, and the tribunal passed order that rejected the petition, put up latter for argument. Means post lunch, he took up the matter for argument in our absence, passed the award. We only pray, my lord, let him give an opportunity of hearing. That's all. We are striving for that only, man.
Where is the workman, sir? Without hearing the workman, we can't pass orders.
Lord, we have in
know
fact
the
sought
age
a
of the workman, nothing you know.
But we have sought a copy of the earlier counsel appearing in the connected matter. I can take out notice by special messenger or by Lord.
You say the none is appearing for the opposite party number 2 workman. Mr. Atul Leonard, consul petitioner, states that he will have a fresh notice issued. You say issue fresh notice to opposite party number 2, returnable on 30th November, 30 November. Yes.
Weekly list item 28.
Item 28 also by efflux of time the matter became infructuous.
All right.
I am for the opposite party.
All right.
Weekly list item 29.
None appears to Susano.
Weekly list item number 30.
Lord, here in this case, I don't have any instruction.
All right. Consul the petitioner
Item
states
number
yes,
40 also no instruction, madam.
all right. 30 and 40. All right.
30 and 40.
Weekly list item 31.
Yes, sir.
In fact, so far as the license renewal part is concerned, this is no more existing, my lord. The cause is already gone in view of the lottery and your lordship judgment, madam.
Right.
Now, only question of exemption during closure period. Lordship may remit me to go to the state government in view of the earlier orders passed by your lordship. Not I can give
Your lordship is remitting back to excise.
All of
no state
Patras
government
matters. Arun
Yes.
Patras.
No, state government rule 151 says collector is authorized to exempt with approval of the government, not the commissioner. With the approval of the government. Kindly see rule 51 of excise rules.
It's okay. Government can
So
be that.
yes, the government should take a call.
As regards exemption is concerned, government,
Yes.
because commissioner cannot exempt.
Right. Rule 151, refund exemption anyway, anything. And we are asking for refund.
The prayer regarding shifting of the shop is no longer surviving. As regards refund is concerned to be open to the petitioner to approach the government, is it?
Right.
For appropriate relief in accordance with law.
The government will take into consideration these earlier orders. Not that may be kindly observed.
In considering the said application, the government will keep in view the decision of this court dated 27/1/2016 in writ petitions number civil number 6779 of 2015 practice Shakti Prasad Mohanty versus State of Orissa. All right.
Grateful.
Weekly list item 32.
Appearing in this case, your lordship will find that this is a petition against the chief commissioner for giving relief under section 234 C and B of the Income Tax Act for non-payment and deferment of payment of advance tax. Now, in this case, no counter has been filed, and your lordship kindly see the order sheet.
So there is no interim order as well.
No, Minister, I have paid the tax. I have said that I have paid the interest in the event of success. And here what has happened, after the chief commissioner received the petition, he asked for a report from the chief commissioner, who had already passed an order under section 234 C, B and C. And he gave a report. That report is entirely in support of the chief commissioner doesn't want to rely on that report and reject that he doesn't have any power.
Who's for the department? Who's appearing for the department, sir?
No, Mr. Mahapatra was appearing and Mr. Das was appearing. Mr. Mahapatra has expired. Mr. Das is no more the standing counsel.
We can pass it over, sir. Let somebody from the department come. All right.
Lord, your lordship may direct me to take notices now.
No, if the department lawyer is here, then there's no need for that, sir.
Because they have
Notice, I'm presuming notice has already gone in the matter.
No, it has come back. This is ADA has not come back.
So it's a 2013 matter, sir. We can't keep it pending like this.
No, I'm ready in this matter. Because
No, but we'll have. I can't hear you in the absence of department counsel.
No, I do not want also.
So we'll pass it over. You kindly request somebody from the department to remain present when we call it again, sir. Yes.
I could list item number 33. Item number 33.
None appears this is not possible.
Weekly list item 34.
But I have for the OP number 4.
All right. None appears this is not possible.
Weekly list item 35.
Item 35, my lords, no instructions.
No instructions disposed of.
Weekly list item 36.
May I please, let's kindly have a glance to the order number 7 dated 16/3/2018. And thereafter the order. Here the state additional government advocate was directed to take instruction in this regard. The relevant portion of the order is, of late, the department has formulated a policy to deal with such irregular cases and a policy decision in this regard is being awaited. Unless the policy decision is arrived at, it will not be possible on the part of the opposite party to entertain the prayer of the petitioner. It is appropriate on the part of the additional government advocate to take appropriate instruction in this regard and apprise this court on the next day. This the matter on 30th of March 2018. Thereafter, though the matter was listed, my learned friend had taken time but has not apprised to the honorable court regarding what is the policy decision taken by the state. Is there any
Next week, your lordship may fix it to next week, next Monday. I will.
Mr. D.K. Manthi, learned counsel appearing for the additional government advocate. Seeks some more time for instructions. List on 23rd November.
Weekly list item 37.
None appears this is not possible.
Weekly list item 38.
None appears this is not possible. Pass over. 30 pass.
Weekly list item 39.
On behalf of Mr. VP Tripathi appearing from opposite party number 1.
All right. None appears this is not possible.
Weekly list item 40.
40 is disposed of.
Weekly list item 41.
41, I am for the opposite party, my lord.
None appears this is not possible.
Weekly list item 42.
42, no instructions.
All right. No instructions.
Weekly list item 43.
Memos taken on record. No instructions.
Weekly list item 44.
None appears this is not possible.
44, I am for the OP.
Weekly list item 45.
Pass over, lordship.
All right. Pass over.
Weekly list item 46.
None appears this is not. Wearing a senior gown.
Weekly list item 47.
Unappeased, this is not possible.
Weekly list item 48.
38, my lord, the rejoinder is ready, my lord. You lost me that as the petition is suffering from corona, my lord. Therefore, lost me take up next week, my lord.
Which one is this, sir?
48, my lord.
48. If the counsel, the petitioner is stated to be unwell. It's on 30th November.
Weekly list item 49.
Infosys, my lord. I am for the opposite party, Infosys, my lord. Answer to man.
All right.
Weekly list item 50.
Item 50, my lord, sir, infructuous, my lord.
Save.
Weekly list item number 51.
My lord, 51 petitioner is dead and
All
we
right.
have not got information from his substitution.
All right, sir. All right. Petitioner is dead. Mr. Serving awaited.
Weekly list item 52.
My lord, item 52, my lord, I'm appearing online. My lord, may I pray, my lord, this matter to be taken up 2 weeks after, my lord, my senior Mr. Sen, Sanjay Sen is appearing. He's suffering from COVID, my lord.
All right. Counsel for the petitioner is stated to be unwell. Learned senior counsel appearing to petitioner is stated to be unwell. It's on 30th November, 30.
Weekly list item 53.
None appears. Dismissal no possible.
Weekly list item 54.
Same.
Weekly list item 55.
55, my lords. I'm filing rejection, my lords. I think it can be disposed of on a simple ground. Means what happened? This property, my lords, in Annexure 1, my lords, this was settled in the name of my lords, predecessors, my lords, way back in the year 1932. This is a past settlement. Thereafter, my lords, it has come to me, my lords. While matter stood thus, the OEA proceeding was initiated and the Tahsildar settled that land in my favor. Thereafter, some of the persons, they preferred appeal. And in appeal, it was remanded. And after remand, the Tahsildar again deleted my name and they wanted to record it otherwise. I preferred again appeal. And against that appeal also, the appellate authority remanded the matter. Thereafter, my lords, kindly have a glance to page 36. Page 36. Without giving any notice to me, and the Tahsildar, my lords, recorded the land in the name of the government. 94 years, my lords, we are in possession of that property. We are since 1994 months to 1932. But thereafter, my lords, what happened? Immediately thereafter, my lords, they initiated a proceeding under my unauthorized encroachment case and wanted to evict me. Against that, I have come before the Honorable High Court. Well, I am conscious of the situation that this order of the settlement that Tahsildar as OA collector is appellable. I must kindly have a glance to my rejoinder. In the meanwhile, I prefer, my lords, after getting that interim order, I prefer that appeal before the sub-collector in case number 3 of 2013.
Yes.
Still pending. 3 of appeal number 3 of 2014.
No, is it still pending?
This is pending. My humble contention that appeal may be considered.
Correct.
Till then, my lords, I may be protected.
Of the petitioner indicates that against the order passed by the OEA collector, the petitioner has already preferred OEA appeal case number 3 of 2014, which is pending before the appellate authority and sub-collector Badrak. Full stop. That view of the matter, permitting the petitioner to pursue the said appeal in accordance with law, the present petition is disposed of. The interim order dated 19th August 2013 will continue till the disposal of the aforementioned appeal. The court directs the appellate authority, that is the sub-collector, Badrak,
sub-collector Badrak,
to dispose of the said appeal, if not already disposed of within a period of 4 months from today.
Weekly list item 56.
May I please, your lordship? The petition has been referred this writ application challenging the order of the rejection under Annexure 3, page 12, my lord. The order of rejection, the petition file of recalling the petition, which has been rejected on 25th June 13, my lord. And in the meantime, my lord, on the matter of the posted to 27 July 2022, and subsequently that has been fixed to 23rd August 2022 for evidence, my lord.
So why should we interfere now?
Your lordship has disposed of the matter. Your Lordship dispose the matter and
The petitioner states that the matter is now fixed before the Labour Court on 23rd December.
23rd August
2022, permitting the petitioner to pursue the matter there in accordance with law.
My name be recorded. I am for the opposite work.
The petition is disposed of. Correct.
Public.
Weekly list item 57.
None appears to assist in opposition.
Item 58.
None appears to assist in opposition.
Weekly list item 59.
59, I am there, my lord. No counter has been filed. Here, if your lordship looks at Annexure 3, the land has been settled in favor of the petitioner's father. There are 2 sons and 2 daughters. And the record of right was also issued in his favor. Page 14, lordship, kindly see Annexure 3. Page 14. That is the order passed by the Tahsildar. At page 15, second paragraph. Under the circumstances, I settled the land of 5 acres in Mauja Jagdal under Khata number so-and-so in favor of Prasanna Kumar Das, son of Lokanath Das. He was an ex-Navy person, married. But the pata was granted next page. If you look at page 16, the record of right is there on Sthitivan status. But the 2012, the father expired. He lost his, the file was entirely misplaced. Somewhere else he kept it. The children actually, they wanted the Tahsildar to supply a copy of it. And that was not given. The deed has been filed.
Yes. What the state has not in file a reply. What are instructions? Need time.
I don't have instructions.
Council, the state seeks time for instructions. List on 30th November. There's an interim order, sir.
But there actually, pata has been granted.
No, there is no interim order.
There is no interim.
But it's not necessary because they have been granted the benefit of the pata also.
Oh.
The record of right was granted in their favor.
All right.
Weekly list item number 60.
We'll discuss. I am applying for approval 1 and 2.
All right.
File counter Miller discuss.
None appears dismissed a non-prosecution. Right.
Weekly list item 61.
File it to the registries of
item 61.
None appears dismissed a non-prosecution.
Weekly list item 62.
None appears dismissed.
I appears for the opposite part.
Weekly list item 63.
None appears dismissed a non-prosecution.
Weekly list item 64.
64 no instruction.
No instructions dismissed.
Weekly list item 65.
65, I want to withdraw with a liberty to approach the authority, my lord, because the revisional court has not considered some points.
To withdraw the present petition with liberty to approach the authorities in accordance with law. Disposed of is withdrawn with liberty is grateful.
Weekly list item 66.
I am appearing for the petitioner, but there is no instruction, my lord. Just my name.
No instructions dismissed.
Weekly list item 67.
None appears dismissed for numbers.
Weekly list item 68.
68 millers, I have enclosed in this case flag B, you also kindly see. I have enclosed Supreme Court judgment, you also Annexure 4. In that, millers, I have made a representation under Annexure 3. Lords may dispose of according to that judgment.
All right. Counsel the petitioner. Praise for withdrawal of the present petition, liberty to approach the authority. In terms of the order dated 2nd May 2022 of the Supreme Court of India and SLP Civil 7785 of 2022.
Obliged.
Disposed of is withdrawn with liberty is granted. This petition was registered on the basis of a letter dated 9th October 2013 of the petitioner regarding steps to be taken during Durga Puja at Bhubaneswar in 2013. Clearly, the petition has become infructuous. It is disposed of as such.
Weekly list item 69.
None appears dismissed in opposition.
Weekly list item 70.
My lord, 70 I have for the petitioner. The pure question of law, my lord. Your lordship kindly peruse the impugned order at Annexure 5. Page 22 is relevant. Here, NOC has been rejected. on the ground that permission was not accorded by the vendor. The fact remains, my lord, the law has been introduced in the year 2012. That is Rule 4A of the Orissa Hindu Religious Endowment Act. And this alienation was 1994. So that is the only pure question of law. So then it was not there. Pursuant to judgment of this Honorable Court, that has been inserted by the state government. So that has not been considered by the learned commissioner. Pure question of law, Your Lordship, kindly have a glance to OHRE Rule 4A when it was inserted.
So now this fact situation has changed since some 2013.
My lord.
Now we are in 2022. You apply a fresh, sir, we'll ask them to consider it without reference to the impugned order.
Yes, ma'am.
Yes, in consideration to the judgment of this.
Yeah. Not since the fact situation on the ground has changed in the last 9 years. The court permits the petitioner to apply afresh for permission to sell the properties of the deity by making a proper application to the Commissioner of Endowments. So if such application is filed not later than 1st October 2022, it will be considered on its merits in accordance with law by the Commissioner, and a fresh order shall be passed thereon within a period of 2 months without being in any manner influenced by the impugned order dated 23rd September 2013.
Deeply obliged.
Petition is disposed of the purpose.
Weekly list item 71.
None appears disposed. No.
Weekly list item 72.
This matter is disposed of.
None appears in this application. Dismissed on offer section.
Weekly list item 73.
Pay for modification of order dated 29/8 of 2012.
You can't have a 28 September 2012 order modified in 2022. How can we modify it 10 years later, sir? You say due to efflux of time, the present application become infructuous, it is disposed of as such.
Weekly list item 74.
No instructions disposed of.
Weekly list item 75.
Enough time to comply. None appears dismissed for now.
Weekly list for admission item 76.
None appears dismissed for now.
Weekly list item 77.
None appears dismissed for now.
Item 78.
If item 78.
Yes.
In view of the present that ongoing PL Chilka PL, it will become infructuous with the now there is no policy existing policy, let's see.
All right. It's disposed of as such. All right.
Weekly list item 79.
None appears dismissed now.
Weekly list item 80.
None appears dismissed now.
Weekly list item 81.
81, no instruction.
No instructions dismissed.
Weekly list item 82.
This is a serious and urgent matter to prevent Revensa from becoming a trade center. The last order of this Honorable Court was 9/7/18. Learned additional government advocate prays for and is granted 2 weeks further time to file counter affidavit. He has not filed. And in the meantime, 4 years have lapsed.
You were concerned about the prospectus of 1819, sir. Now we are in 2022.
Yes, sir, this is not coming. Revensa cases are not coming. I take 1 week after. It may come along with other WPCs regarding Revensa.
No, what is the problem? I'm not able to understand. What is the problem with the brochure that they've issued? You've challenged the brochure. This is of 2018-19. It's already
My lord,
infructuous, sir.
even
The
12.
admission prospectus of 2018-19, you're challenging.
No, I am not challenging you.
Just see your
I have
prayer.
already challenged. They
Just
have
see
not
your,
given.
1 minute, see your prayer, sir. Prayer 1 is what? To quash annexure 1.
That has become infructuous.
Then
The prayer second is existing.
no, that is regularize self. What is regularize? What does that mean? I don't know what is regularizing self-financing course. What does that mean?
I pray 1 week time.
Sir, tell us
along with
what
all-
it is. Not
so
simply
that
adjourn.
it will be easy, my lord.
No. This is not very difficult for us. For you, it may not be easy. For us, it is no problem at all.
We don't want self-finance courses in Revensa. Initially, it was started by some private players and they created a havoc in the campus. We went against
Anyway,
them.
this is about 2018-19. If there's any fresh cause of action, you file a fresh petition. The prayers in the present petition have been rendered infructuous due to reflex of time. If any fresh cause of action survives, it will be open to the petitioner to seek appropriate remedies in accordance with law.
My other PLs are pending, my lord. Kindly.
We'll dispose them off also. Just give us the numbers. In view of the order passed today, take this on board. In view of the order passed today, these petitions are also disposed of. All right.
Weekly list item 83.
My lord, I am for the petitioner, your lordship. I am suffering from throat infection, your lordship. Give me some day, your lordship.
All right. What's the matter about, sir?
Matter about, your lordship. This is the matter supply of water for Rabi crop of Potra Dam of Nuapada district, your lordship. The dispute is continuing since 2012, your lordship. Till date, that has not been solved, your lordship. I will file a details note and, my lord, give me some day, your lordship.
Counsel, the petitioner is stated to be unwell and his request list on 6th December.
My lord.
My lord is keeping it to
6th December, sir. Weekly list item 84.
May please, your lordship. My 3 villagers were using the Adi as a passage and also Jalasya for agriculture purpose. But the Tahsildar has converted the Jalasya to non-agriculture land.
Representation is there already.
Annex 1. We have filed for inquiry this matter because the RI has given the report that would list page 18.
Petitioner's representation shall be examined by the Tahsildar.
By the
collector Ganjam, and after issuing notice the petitioners as well as the opposite party number 5.
Yes.
And after giving them a hearing, a reasoned order should be passed not later than 1st November 2022. The court clarifies it is not a factor. Petition is disposed of. All right.
Weekly list item 85.
May I please? My lord, here in this case, my lord, petitioner paid for implementation of the IPH's guideline that is under annexure 2, my lord, in Bangriposi CHC, my lord.
Your representations are there, madam?
Yes, my lord. The presentation is under annexure 2, my lord.
But nothing to show it's been delivered. You make fresh representations if any cause of action survives. Permitting the petitioner to make a fresh representation to the authorities if any
I am asking for a Union of India.
All right. The petition is disposed of. And after following up on such representation, seek appropriate remedies in accordance with law. The petition is disposed. All right.
Passed. Weekly list passed on matter item number 19. Item number 19.
18.
No.
19.
19. Surya Kanti Sahu.
But in this matter, lordship, the petitioner has challenged the constitutional validity of a certain notification for appointment of lordship, that is Jogan Sahayak lordship under the PDS scheme. And
before my learned friend starts, let's see rules that my learned friend has referred here, rule 212 and 219. In fact, that those rules have been repealed. And thereafter, my lords, in 2014, the new Gram Panchayat rules have come. So in light of that, my learned friend might have to amend.
In fact, lordship, here, lordship, my humble submission, lordship, kindly say I have challenged the constitutional validity. Right or wrongly, the law has been amended.
but which the
Repealed, not amended.
No, that is their lordship. I will satisfy lordship. That is there. Only they have changed the numbers, lordship.
No,
that
repealed.
No, not repeal, lordship. Not repeal. That was earlier.
Repealed and
No, earlier it was 2017. Now in another form, lordship. The same provision is there.
Sir, repeal is repeal. If it has been re-promulgated or
No, my lord. That particular rules is there, lordship. The lordship kindly see for a moment. What is Gram Panchayat 133? Lordship kindly see. That's still there, lordship. 133. But my preliminary submission here, lordship, because when I'm challenging a constitutional validity, the secretary should come to file an affidavit, lordship, here. But here the DPO has filed affidavit only describing the facts. He has not answered any of my allegations, lordship, because my humble submission, the PDS system with the ownership lies with the Gram Panchayat. It is in consonance with the Article 243G of the Constitution of India. And 11 schedule speaks of lordship at serial number 28. PDS is with the Gram Panchayat. The entire management has to be done by the Gram Panchayat. So as per the Gram Panchayat Act, lordship, the appointment of the staffs also.
1 minute. Which rule?
Lordship, 133 lordship, kindly say 133
135 is the repeal.
Of what?
135
of the Act, lordship.
Of the Odisha Gram Panchayat Rules 2014.
Let me press my case first. We'll answer everything. 133 lordship, kindly see. I'm relaying the particular provision, lordship. Appeal. 133.
Yes.
130 speaks of lordship, I'm reading. Shall has otherwise provided in this act or the rules made thereunder, any person agreed by an order or direction made or issued by the Gram Panchayat under this act or under any rule or bylaw may within 30 days from the date of such direction or order appeal to the sub-divisional officer who may vary, set aside or confirm said order or the direction. That is very provision is there, lordship. With my humble submission, when the appellate authority is the sub-collector, how can he be the member of the selection committee? Once so he cannot decide because if somebody will agree, it relates to appointment assistant of employee of the Gram Panchayat.
No. What are you challenging? Tell us.
I am challenging the notification of the state government in appointing Jogan Sahayak in every Gram Panchayat, and they have a constituted body comprising sub-collector, block dump officer, and Gram Panchayat. Lordship.
Show us what you're challenging.
Lordship, kindly see Annexure 1, lordship, that is notification 27/4/22.
Yes.
12, lordship.
Yes.
Lordship, here, lordship, pursuant the government notification, the state government has come up with a decision for smooth implementation of PDS materials, lordship. Lordship, they will engage Jogan Sahayaks in every Gram Panchayat, lordship.
No, what is wrong with this letter? Tell us.
Letter means, lordship, they have a constituted body, lordship, like I say, last paragraph. It will be comprising with the sub-collector, block dump officer, and sarpanch. They will make a panel, and it amounts to the curtailing.
You're not reading anything, sir. I don't know why. Where are you reading? You're just arguing without reading.
Lordship, notification dated 27/4/2012, lordship.
Yes.
Lordship. The GP, lordship, I'm reading, lordship. The GP shall make a resolution in their meeting to appoint Jogan Sahayak if they are dealing with at least 150 quintal of PDS time rice, wheat, sugar in a month. The resolution also indicate the amount of honorarium for Jogan Sahayak between rupees 3,500 to 4,000. The resolution shall be sent to the BDO. The BDO shall collect all such resolution from the GPs and make a common advertisement inviting applications for interested candidates. The eligible candidate shall be as under. The candidate should be a permanent resident of the Gram Panchayat. He should be graduate. He should be age of 21 to 35 years. The selection will be based upon career making, with matriculation being 30% plus to 30% and plus to 40%. A committee under the chairmanship of BDO, plus this is very important, with MIs as convene as convener of concerned Sarpanch of GP as member will do the selection and provide the panel of 3 names to the collector / sub-collector as decided by collector for approval. Upon approval by the appropriate authority, the panel names will be provided to the Gram Panchayat for appointment of the first person scoring the highest marks. So this particular the procedure is challenged and before Lordship. My humble son, Lordship, kindly see, your Lordship kindly see the Article 243G for Movement of Constitution of India, Lordship.
Yes. Yes.
Lordship.
What is the point you're making, you tell us?
Let's see here, Lordship. If Lordship can see the 243 speaks of Lordship. Lordship, I'm reading again. I'm reading particularly G. Powers, authority, and responsibility of the Panchayat Lordship. Subject to the provisions of the Constitution, the legislature of a state may by law endow the Panchayats with such powers and authority as may be necessary to enable them to function as institutions of self-government, and such law may contain provisions for the devolution of powers and responsibilities upon Panchayats at the appropriate level, subject to such conditions as may be specified therein with respect to the preparation of plans, economic development, and social justice, the implementation of schemes for economic development and social justice as may be entrusted to them, including those in relation to the matters listed in the 11th schedule. Lordship, kindly have come to 11th schedule, Lordship, for a moment.
Yes.
At 11th, Lordship, kindly serial number 28.
Yes.
28 is a public distribution system.
Yes.
So in concern of the Article 243G, Lordship, the PDS comes with the purview of the Gram Panchayat, the management lies with the Gram Panchayat. So as per the statutory provisions, if there is a post to manage, the government has come up this notification for to implementation the PD systems, Lordship. Where if the Panchayat is capable to supply more than 150 quintal of rice, then Lordship, the Gram Panchayat is free to engage a person to distribute the same. So when the statute provides a particular procedure to give appointment to his own employees, by making such provision, by bringing the picture to the block ground officer and the sub-collector, collector, this is curtailing the power of the Gram Panchayat. No. As has been, yes, Lordship, Lordship, I'm coming to Lordship. Lordship.
Sorry.
Lordship, I'm coming to the Lordship.
Yes, yes.
Lordship, can
only for engaging some Jogan Sahayak.
Jogan Sahayak is the employee, Lordship. Can
the Sarpanch is very much there, sir.
So, Sarpanch has nothing to do, Lordship. Lordship, Sarpanch has nothing to do.
Why?
He is the only convener, Lordship, he is the only convener, and he will recommend the name to the block ground officer, and block ground officer will send to the BDO collector for approval.
So what is wrong with the procedure?
But this is, Lordship, kindly see, please don't disturb, Lordship, when I am arguing.
Yes.
So you are misleading.
Lordship, what mislead?
1 minute.
Arguing counsel mislead, Lordship.
Sorry.
Lordship, how can he say how to mislead, Lordship? The court say to mislead.
Pass over.
Lordship,
don't raise your voice like this.
What is
this kind of behavior?
I don't mind, Lordship. I don't mind. But how can he give a statement that I mislead?
When we are asking you a question, you're turning around and
he say that I am misleading.
You're not.
No, then I'm sorry, Lord.
You're not even letting me complete a sentence.
No, then I'm sorry. Then
pass over now. I have to learn lessons from you in advocacy ethic. Kindly sit down. Calm yourself down first. Kindly calm yourself down first.
Lordship.
Yes. Follow the next
Pastor matter item number 32.
My Lord, 32. My Lord, in this case, Mr. Satpathy would be appearing, and he wants a copy to be given to him. I will serve a copy in this matter for day after tomorrow.
Where is the copy, sir? Who's appearing?
I'm appearing for the petitioner.
No. Who is appearing for the department?
Mr. Satpathy.
Where is he?
I have informed him. My young friend has informed him he wants a copy.
All right. Mr. Mohanty states that Mr. Satpathy has been informed. Mr. T.K. Satpathy, standing counsel for the department, income tax department, has been informed, and a copy of the petition will be supplied to him within 2 days. List on 7 December.
17th.
7th December.
7th December.
Pastor matter item 38. Item number 38. Item number 38.
The innocuous prayer is to dispose of the representation.
But who's appearing?
Page 5 of the writ petition.
But who's appearing?
No, Mr. Nanda is not there. Mr. Mohan. Item 38, WPC 12610. The prayer is to direct the opposite partner 1 and 2 to take decision on their representations annexure 2 and quas annexure 4 series.
None appears despite a passover. Dismissal not possible.
Pastor matter item 45.
May I please, your lords?
Item number
This is an
45.
application where, my lord, the land of the petitioner has been acquired by the state government and
Before my learned seniors, addresses your lordship, after a short time may be given to me to file a counter affidavit because
Not at
certain
this
new
time,
developments.
sir. 2013 matter. Where's the personal counter now?
New developments have come in, which I have received yesterday only.
Or counsel with MCL states that there are some new developments on which he has received instructions. He seeks and is granted 4 weeks time to file an affidavit. What response thereto, if any, be filed with the petitioner before the next date. List on 12th December.
Item number 19.
I may pardon. Item number 53 and 54, dismiss for default. It is covered by your lordship's order, my lord.
All right, 53 and 54.
My lord, 57.
1 minute, sir. 1 minute.
I have corrected it with regard to imposition of transport fee.
All right, same order. All right.
Obvious, 53 and 54.
Yes, what is your item, sir?
My 57.
53.
What is that?
That is a matter in which by suppressing facts in 2 writ appeals, in 2 writ petitions, they have taken order that they will draw money, though they have no title over the property. That is.
So you have to go to the appropriate forum for that, sir.
My lord?
You have to go to the appropriate forum for that, not here.
No, my lord. The opposite party have taken order from this honorable court in 2 writ applications. I am giving to.
So you'll have to file in those applications a review petition or whatever, sir.
My lord?
You'll have to file a review petition or whatever in those applications, those writ petitions.
No, I am not a
party.
My lord, I was not party in that.
So we permit you to apply so that you have to serve copies on the other side, sir, in that.
My lord, let it come next week. I will do it.
This is not the remedy for that, sir. You can't file a writ petition to challenge an order in another writ petition.
But I was not a party in that case.
Correct, sir. So you have to file a review. You have to apply for permission to file a review and file a review. I don't know why we are giving you free legal advice, but anyway.
Well, that's true. But the hurdle will be that I was not a party in that case.
Which is why, sir, you apply to file a review. All right. You apply to seek permission to file a review.
My lord. Let it.
Counsel, the petitioner seeks leave to withdraw the present petition with liberty to seek other appropriate remedies as may be available to the petition in accordance with law. As post office withdrawn, liberty is paid for.
19.
19 Lordship, my pray. Can it be other day, Lordship? Can it be?
You're not cooled down yet.
Not, I have cooled down, but I will try my best another day, Lordship.
Sorry?
I'll try my best other day, Lordship, too.
No, sir. We don't have so much time. Can you continue from where you left off?
Lordship.
You want to challenge the procedure for appointment of a Jogan Sahayak.
Lordship, prior to that, Lordship, I want to draw Lordship's kind attention. The three judgments. One judgment is the full bench judgment of this honorable court.
Yes.
Lordship, only. It is of 1992 OLR, Lordship. This judgment, Miller law has been well settled. The employees of the Gram Panchayat are not holding civil post, Lordship. And any interference by the Miller officers of the state, that is bad in law. So this is the judgment of 1990, Lordship. Then if Lordship, another two judgments, this is 2007 to ACC 138, UP Gram Panchayat Adhikari Singh and others versus Daram, Saroj and others. In this case, let's say Supreme Court has laid down the law. Article 243 is an enabling provision, Lordship. It is up to the state to make a law. But in presence of law, they can deviate to that, Lordship. That is the Miller judgment there, Lordship. But in view of the Article 243G, here the state government has already enacted the law, Lordship. Here law speaks of, Lordship, see the rules 2014 amended present rules, Lordship. 123 rules, 125, Lordship. But here the state government has enacted the law.
Yes.
Miller 125 speaks of, Lordship, appointment of staff.
Yes.
The Gram Panchayat may, with approval of the district panchayat officer, but it is the earlier provision also, Lordship.
Yes.
The district officer of the district office, officer of the district appoint secretary or other staff like scavengers, tax collectors, persons, etc., as may be necessary for enabling to discharge its duties and perform its function for carrying out the purpose of the act and rules made thereunder, subject to condition that remuneration of staff appointed under this rule shall be paid by the Gram Panchayat out of its own internal income, and no part of the such remuneration out of grant allotment sanctioned by the government, Lordship. So this is the existing law, Lordship. And your Lordship, another law, Lordship, can say another of the division bench judgment of this honorable court. It is reported in 2008 to OLR, Lordship, this Fakir Mohan Das versus Government of Orissa. Here, Lordship, your Lordship has laid down the law in view of Article 243G. Any interference to the affairs of the Gram Panchayat by the office of the state is bad in law, Lordship. So it amounts to curtailing the power of the Gram Panchayat. But in this present, Lordship, this is the three judgments I am relying. But in this case, Lordship, kindly see, I brought a Lordship's kind attention to the Article 243G and 11 schedule. The PDA system with the ownership lies with the Gram Panchayat, Lordship. And the Gram Panchayat Act itself speaks of, Lordship, particular procedure to appoint his own employee. So the simple provision is, Lordship, principle is, Lordship, the post is to be appointed by the Gram Panchayat with approval of the district Panchayat officer. That is the statute says, Lordship. But in this context, what they have done, Lordship, kindly see. In the Lordship, they have appointed the collector and sub-collector who is under the Gram Panchayat Act. They are the appellate authority, Lordship. Lordship, see the section 133. They are the appellate authority. Himself, they have been indulged in the selection procedure. So much of the person is remediless. A person, if a person will be agreed by the selection procedure, then he lost his affiliate from, Lordship, because the collector and sub-collector becomes the member of the selection committee. So in view of the Article 243G and 11 schedule, Lordship, and when the ownership of the petition lies with the Gram Panchayat, so in a self-governance system, let the collector and the BDO should not interfere with the selection procedure, Lordship. That is, Miller, that is my submission. We will contract to the Miller, the constitutional provision and statutory provision.
That's firstly, Miller, this Jogan Sahayak. is not an employee of the Gram Panchayat. My lords, the parent notification, in fact, is annexed in my counter affidavit. My lords may see page 7. It is dated 21st of April 2012.
Yes.
The impugned notification is a sequel to this, where, my lords, all the BDOs have been asked that all the Gram Panchayats should take a call, recommend a Jogan Sahayak, which will thereafter be put before a committee where the concerned Sarpanch is a member very much, and the BDO. And my lords, so my lords may see page 8.
Procedure for appointment.
Procedure for appointment. My lords, my lords may see point 4. Commission for FPS retailers under new system. The FPS retailer will get a commission of rupees 20 per quintal and the 2 gunny bags, which will also fetch 20 for delivering PDS items to ration card holders. This would make the PDS operation profitable for the FPS retailers, as they would be able to recover the cost of operation easily. Because this comes, my lords, from the Justice Wadhwa Committee. My lords, I may not have to, my lords, put it before my lords. If institutions like Gram Panchayat, self-help groups and cooperative bodies take up FPS retailership, they would not only make profit, but can engage and educated youth as Jogan Sahayak on contractual basis with remuneration of about 4,000. But to do that, they should have an allocation of at least 150 quintals of PDS per month. So therefore, my lords, the money that has to be paid to the Jogan Sahayak will come from this profit margin. It is not, my lords, coming from the corpus of the GP.
Yeah.
That is point number 1. Thereafter, my lords, procedure for appointment of Jogan Sahayak, which my learned friend was referring to. My lords, page 9, second line. A committee under the chairmanship of BDO with with so-and-so as convener and concerned Sarpanch of GP as member will do the selection and provide the panel of 3 names to the concerned GP for appointment of the first person as GS. So there are 2 points. First is that this Jogan Sahayak is not an staff coming under Rule 125 of the Odisha Gram Panchayat Rules 2014. Second, my lords, the money that the remuneration that is being paid is coming from the profit margin. It is not coming from the corpus. So therefore, there is no interference with, my lords, the functions of the Gram Panchayat, or there is no interference by the government. So that is, my lords, the point. And in the first petition, at least, the person who has been recommended by the Gram Panchayat is the son of the Sarpanch itself. And therefore, my lords, this petition is in the guise of giving that particular person a permanent post. So that is, my lords, the issue. And that, my lords, I have given in para 3 of my counter. At least in the first petition, my lords. The companion petitions are separate. Para 3. It is further submitted that the present writ petition is an outcome of malified action of the petitioner, who being the Sarpanch of Sirjapalli GP has given appointment to her son, Pradeep Kumar Sahu, as the Jogan Sahayak in violation of so-and-so. Because, my lords, the recommendation has to go to the BDO and the Sarpanch is a part of it, which, my lords, is the petitioner here. So, my lords, this is...
All right.
Great.
What about the other petitions?
Means the other petitions also are on the same line. My lords, the stand of the state is that the 2 points. That first is that the remuneration is being paid from the margin, the profit margin. And the second is that the Jogan Sahayak is not part of the staff of the Gram Panchayat.
All right. Yes, Mr. Dale.
That's it. So for the submission made by London Council Affair for the state that the profit is coming not from the Gram Panchayat is not a correct statement, Lordship. Lordship, kindly consider, Lordship, one aspect, the PD system with the Gram Panchayat. It is my domain, Lordship, to take out the profit and to give the salary. That is the notification, it's the crux of the notification, Lordship. So the profit always comes with the Gram Panchayat. It is not of the state government. So it is my lookout to engage anybody or so.
That's where arbitrariness steps in, sir. No wonder you want to save the appointment of your own son.
No, Lordship, that is the Lordship. Lordship, it is Lordship.
All nepotism,
Lordship, there
favoritism, everything will start.
No, Lordship, there is 4 applications. Lordship, kindly consider there are 4 writ applications.
Yes.
In one writ application, their point all are in similar line.
Right.
But in one application, they are pointing out, they're fingering me. In first writ application, he is my son. But Lordship, kindly see that his appointment can it be in a backdoor procedure? The Gram Panchayat has invited applications in consonance with the procedure as laid down on the Gram Panchayat Act. There are various participants, and the Gram Panchayat has selected this person, and who happens to my son. But Lordship, is there any prevention, Lordship? So my learned phrase appearing that is also he is the beneficiary of the same legislation. This is the legislation gives a power to appoint to give this monopoly and to appoint the particular procedure laid down. Many persons are coming, my friend is also not coming in the fair selection procedure. This is the laid down statute has given a simple power to monopoly with the state to appoint somebody. But here, Lordship, I have come up with a selection procedure where the Gram Panchayat made selection to my son, not to me, Lordship, not by me. And Lordship, kindly see. Joy practice kari.
Yes.
Lordship. So, Lordship, the action of the state government, I am not saying, Lordship, the purpose is bad in law. Lordship, kindly see this legislation. Earlier, this PDS system was vested with the supply department. It is under the revenue. At the long run, Lordship, after obtaining several judgments, after coming up with Vadha Commission's report, Lordship, the government for the first time in 2012 decided will hand over the PDS system to the Gram Panchayat. So it is for the first time in the 2012, the state government take a conscious decision to hand over the PDS system where the ownership lies the Gram Panchayat. It was never with the Gram Panchayat. But my humble submission, they committed a mistake on the same day by not giving the full authority to the Gram Panchayat to appoint his own staffs. If they are saying this person is a government staff, I have nothing to say, Lordship. This is their own domain. They appoint their own staff and they will take care of him. If this post is lying with the Gram Panchayat, it is my post, then Lordship, definitely I will give them appointment as per law prescribed by the state government. The present enactment, this present amendment says a particular procedure how to appointment our own staffs. How can the appellate authority will be the member of the selection committee, and how do the government officials interfere with the selection procedure and they will be the panel. In this, Lordship, kindly see the again cost of the repetition. I am requesting Lordship kindly go through the notification. They have made only the serpents to a party to the selection procedure, only who will convene the meeting. The entire selection procedure and appointment, everything lies with the government officers, and which is contravention to the Article 243G of the Constitution of India. And your Lordship, not only 3 judgments, your Lordship has rendered a number of judgments, and this PDS system, your Lordship have completely handed over to the Gram Panchayat, even if not to the self-help groups also, Lordship. And your Lordship has categorically prohibited in number of judgments not to appoint private dealers, not to appoint self-help groups, and this is the complete and the discretion and domain of the Gram Panchayat to discharge and to regulate the PDS system, Lordship. That's why the state government has come up with the notification. If my learned friend is saying a statement that this post is not with the Gram Panchayat, I have nothing to say, Lordship. I fairly concede if they will say the post with the state government, Lordship, no argument is required, Lordship. They will take care of his own employee. If it is the Gram Panchayat, they are saying the Gram Panchayat employee, then will not right rest with me, with the Gram Panchayat. And it is Lordship's consideration to take a decision on the constitutional point, Lordship. How they have curtailed the power of the Gram Panchayat.
That's it, sir.
Lordship.
All right. Orders written.
Well, let's apologize for the unpalatable situation.
Yes. Weekly list is over.
Supplementary list.
Lordship, permit me, may I give a little note of submission with other judgments are there, such as with this.
All
Oblige,
right.
Lordship. Oblige.
Counsel, the petitioner is permitted to submit a note of submission within 3 days, sir.
Lordship, oblige.
Supplementary stress admission item number 1.
Yes, sir.
At the outset, I must convey belated happy birthday to your
No, please. All right.
Because the atmosphere was very hot.
No, it's all right.
My lords, the other day, I have handed over the 2 orders.
Yes.
Of your lordship, that is in WPC 14723 of 2022. Here the notice has been issued for the assessment year 1314 on 31st of March 2021, which is barred by limitations because it has.
Who's for the department?
Now I've been informed that the other day Mr. Satpathy was not present. Now I've been informed that Mr. Chimanka is appearing.
Is it covered, sir? Mr. Chimanka, is it covered?
Yes, my lord.
All right, same order. Right. All right, sir.
Item number 2.
The public interest litigation lordship, the petitioner is a public spirited personal lordship. The issue involved here, lordship, in 2003, the government has taken a decision to construction of 3 drains in the BMC area, lordship, Barampur Municipal Corporation. Until date, not a single, all the 3 project has not been yet started, lordship. The petitioners, along with the public lordship, they have repented to the authorities, lordship, that is Annexer 1 as page 10, lordship, kindly see. The collector also forwarded to the BMC commissioner, lordship, since lordship 16/12/21, lordship. That has not been yet considered, lordship, by the authorities.
The commissioner, Barampur Municipal Corporation, will consider the representations forwarded to him by the additional district magistrate Ganjam Chhatrapur under cover of letter dated 16/12/2021 bracket Annexure 1 series, and after giving the petitioner a hearing, a reasoned order shall be passed not later than 1st November 2022. The date of hearing should be communicated to the petitioner at least 1 week in advance. The petition is disposed of.
Supplementary list item number 3.
I am for the appellant.
Yes.
Respondent today deposit 25,000 rupees. Other 33,000 rupees pending.
No. You just tell us the number. That's enough. Hand it over to you.
79142.
All right. Counsel for the appellant states that the respondent has paid the appellant rupees 25,000 today. By way of a demand draft.
Demand draft.
Drawn on State Bank of India. All right. Give it back to him.
Other 33,000 pending.
Yeah, for payment of the remaining amount should be paid before the next date. List on 10th October.
Supplementary list item number 4.
My lord, 1 week timing can be allowed.
For what, sir?
This file is not with me.
There's so many files, sir. None of the files is with you.
152, 153, 154. If it is a caption fees, then same order may be passed.
At the request of Mr. Chimanka, list on 21st November.
Supplementary list item number 5.
May it please your lordship. My lord, in this case, your lordship, I have filed an IA 10426 by 2022. My lord, very briefly, your lordship, I am placing the facts.
Yes.
My lord, the petitioners are all qualified and degree holder of diploma in fishery science. Now, your lordship, there is an advertisement by the opposite part number 3, that is Odisha Staff Selection Commission regarding filling up the post of Junior Fisheries Technical Assistant JFTA in short. 67 posts of JFTA were advertised. Now, in the advertisement, your lordship, they prescribed a qualification. The qualification has been based as per the notification of the government under Annexure 3. Your lordship may kindly see the qualification they have prescribed. That is under Annexure 1, I have annexed all my pass out certificates. Annexure 2, your lordship may kindly see page 29. My lord.
Yes.
My lord, page 29, the minimum qualification they say, the candidate must have passed +2 vocational fisheries from CHSC or university and must know swimming well. Candidate possessing +2 science qualification are also eligible to apply for the post. But when the candidate possessing +2 vocational fisheries qualification will not be available, candidate with +2 science qualification will be considered for selection. Now, your lordship, there is an option that in +2 science, one person may take fishery as a vocational subject. Now, we are the persons who have studied 2 years of diploma in fishery science. Your lordship may kindly see Annexure 4 at page Annexure 4, that is page 40. Annexure 4 starts from page 40. That is from 40 to 52.
So this is coming on 22nd anyway, sir.
My lord, the difficulty is that I have filed an IA. When I filed the writ, the advertisement was processed. Your lordship has been pleased to direct me to appear the examination. My appearance in examination will not hamper the writ petition. This is the order your lordship has been pleased to pass. I appeared the examination. Your lordship may kindly see IA number 10426 by 2022, which compelled me to come before this honorable court at an early stage. In 10426 by 2022, they have published the result. That the result is at Annexure 10. Your lordship may kindly see page 7. That is the reason your lordship may kindly consider Annexure 10, page 7 of my IA number 10426 by 2022.
Yes.
My lord, this is the result, and your lordship may kindly see page 8. The next page, that is the list, that is the last selected marks of different categories.
Right.
In the last selected categories, your lordship may kindly see in unreserved category. It is 100 marks examination was done.
Right.
Out of 100, in unreserved category, a person secured 19.5. He is shortlisted and called for the interview. Your lordship may see SCBC category 13.5, SC 11.75, SC women 3.75, even ST 1.75, ST women 1.5. Your lordship may kindly see my contention I have raised in paragraph 4. We have secured 63.75, 50, 30, paragraph 4, your lordship may kindly see, of my IA number 10426 by 2022, paragraph 4, I have stated that it is respectfully submitted that out of 15 petitioners, after scrutiny and verification, 9 petitioners were found eligible to appear the examination. Out of these 9 petitioners, Ratan Munda, petitioner number 3, has been shortlisted in ST category. Rest 8 petitioners have scored the following marks. Amulya Kumar Sahu, that is 32.5. Pratik Singh.
No, don't read every mark, sir. Tell us what the point is.
My lord, the point is that when your lordship permitted me, we are the persons having way more better qualification than the person having +2 vocational science. It is none other than the government who has written letter under Annexure 6, page 57, that the persons holding diploma science in fishery must be given preference over a person who is having only +2 vocational fishery. This is under Annexure 6. And I have also annexed the notification of other states, that is under Annexure 8, state of Andhra Pradesh, wherein at least they have made +2 vocational and +2 diploma and BSc in fishery science. All these are to be considered equivalent, at least, no preference. a person having less qualification, reading less subjects will be given a preference over the person having higher qualification and who has read much more subject in that field. And the government is recommending that those persons must be given preference over them. Without doing that, what they have done, they have given preference to a person having +2 vocational as fishery science over me. The result is that a person securing 1.5 out of 100 is shortlisted. And I have secured 63.75. I have not been shortlisted because he is a candidate available in +2 science with vocational. 1.5% will be called. And I have secured 63.7.
Sir, if you want to argue the whole matter today, then the next date we will cancel it.
My lord,
you make your choice now. We have already listed this case on 22nd August. If you say, sir, I want to argue the entire matter today, you argue it. We will hear you today and the next day will be cancelled.
My lord, my prayer is in the IA that your lordship may kindly stay the process.
No, we won't in a truncated matter, here only the IA, not the main matter.
Because your lordship, the result published on 1st of August.
Yes.
I filed an IA on 2nd of August.
All right.
I made a mention before your lordship on 3rd of August.
All right, sir.
Your lordship has been pleased to direct it to on 8th of August. Matter could not come. So today it has come.
Right, sir. So now you decide. You argue the whole matter, we'll hear you right now.
Your lordship, because of this reason, I have filed this IA.
Correct. We're not hearing only the IA, sir. We'll hear the main matter itself. We can't truncatedly hear the IA today, main matter on 22nd.
My lord, I do accept your lordship. But the reason is that your lordship has been pleased to pass an order on 7/4/2022.
Right.
My lord has directed that the writ petition copy be solved and reply be filed within 6 weeks.
Right.
Now, in the meantime, your lordship, 12 weeks have elapsed.
Right.
They have not filed any reply.
Right.
Now, in the next IA, lordship has been pleased to direct the participation of the petitioners in the selection process would be without prejudice to rights and contention of the petitioners.
So that should be taken to the logical end, correct? Since you participated in the selection process, let that selection process get completed. Whoever is out, whoever is in, but both will be subject to the outcome of the writ petition, correct?
Your lordship may kindly direct that let the selection process even continue, no final appointment order be issued. Otherwise, there is nothing remains in my writ to contest.
No, but all those appointment orders will be subject to the outcome. Then you will have to make them all parties.
That I have written in my paragraph that since an advertisement has only been made, no notice has been, no appointment letter has yet been issued.
We can't hold back all this, sir. Whoever gets selected, you will make them parties. If you are selected, you will be happy.
My lord, there is no chance for me to select it because securing 63.75, I am out from the certificate verification itself.
Right.
They have called to certificate verification those people who have secured 1.5.
So all their appointments would be subject to the outcome of the writ petition, correct?
But if they will be appointed, your lordship, and they will enjoy the post. They
will enjoy the post with the letter saying it is subject to the outcome of the writ petition. They will enjoy the post subject to your making them parties to the writ petition. They will enjoy the post subject to notice being issued to them. They're filing the counter affidavit. All right.
That will, in this
everything you want us to say today, then we'll cancel the hearing for 22nd. You file an application waiting for the result to come. When the names are known, you file an application to implead them. We'll give a longer date.
My lord, that is leading to multiplicity of proceedings. I have come before your lordship at a time when there is only
you're right, sir, because you're not the only person applying for these posts. Several people are applying, correct?
Your lordship may kindly see.
We can't jeopardize the entire selection process because you have come.
We 15 people have come, your lordship.
Yes, but there are so many others who have applied who have done better than you.
But your lordship may kindly see the result. They have called to person those who have secured 1.5.
Which is why you will challenge them, which is why we will entertain the challenge. We will examine it here, sir.
My prayer is that, your lordship, in this situation,
you say IA, you say notice, he accepts notice, reply be filed within 4 weeks. It is clear from the elements in the present IA that the applicants apprehend that they will not make the cut in the selection process.
So we have not been called, your lordship. We have not been shortlisted.
Yeah, that they have not been shortlisted. They are therefore questioning the selection process. Full stop. It will be open to the applicants to file appropriate applications to challenge the final selection list and also implead those who've been selected as party respondents. Full stop. This court has already passed an order that the participation of the present petitioners would be subject to the outcome of the petition. It is further clarified that the appointment of the selected candidates will also be subject to the outcome of the petition. The next date of 22nd August is cancelled. List on 28th November 2022. Meanwhile, you file an application. That application will come up earlier, sir. All right.
Supplementary list item number 6.
May I please your lordship? The present petitioner is a finance company in this case. And the only prayer your lordship in this week petition is for implementation of the Honorable Apex Court order. As per that order, your lordship may
So this is completely misconceived. Just read your prayer clause. Kindly read your prayer clause. Every day I'm learning something new, sir. How to draft a prayer clause. Just read your prayer clause.
It is therefore humbly prayed that this honorable court may kindly be graciously pleased to admit the writ petition, issue notice calling upon the OP to show cause why the relief prayed in this writ petition shall not be allowed.
So prayer clause says the relief prayed in this petition should be granted. But the relief prayed is not mentioned in the prayer clause. This is a new style of drafting, I think. So then we have to hunt for the prayer in the petition, not in the prayer clause. Is this how the prayer clause should be drafted, sir?
Pardon, your lordship. I may be pardoned for this. And
so what do you want to do, sir?
Actually, the judgment of the honorable court notice may kindly be taken into consideration, and appropriate rules may kindly be possible, may be framed.
So there's no compulsion on you to draft a proper prayer. Is there no compulsion on you to draft a proper prayer, sir?
Your lordship, I will amend. If your lordship allow, I will amend the prayer.
No, you better file a proper petition. I don't know. Some execution petitions filed by you in July were not taken up immediately. So immediately you rush to this petition to this court.
Actually, your lordship, the apex.
This is a new way of doing things. You go to the district court, you file execution petitions in July. Within 2 weeks, you come to the High Court and say, my execution petition is not taken up in the district court.
We have filed in the month of April.
Very good, sir. So April you file. If it is not taken up, you immediately come to the High Court.
Your lordship, as per the apex court, within 6 months.
Can you not even approach the district court with an application saying, please take it up early?
We have filed, but your lordship, they have disposed of because they said that we have our own.
Where is the order? Where is the order passed by the district court? Have you enclosed it?
No, your lordship.
Everything is oral. Counsel, the petitioner seeks leave to withdraw the present petition with liberty to seek appropriate remedies in accordance with law. Disposed of is withdrawn with liberty is paid for. All right.
Supplementary list for admission item number 7.
May it please. Yes.
You're appearing to the workman.
Yes, Lord.
All right. Yes, sir. Tell us.
The present writ application has been filed challenging the order in Annexure 3. Just I'm placing few dates, my lord.
Sir.
The petitioner in this writ petition assails the orders passed in Annexure 3 by the presiding officer, Labour Court, Jaipur, in ID case number 44 of 2003, allowing the application under section 33C2 of the Industrial Disputes Act filed by the opposite part number 1, claiming the wages at the revised scale from 1986 to 1991 amounting to such total. 31-184, opposite party number 1 joined as assistant storekeeper. 25-187, he was promoted to junior clerk. 14-890, a decision was said to have been taken, among other things, that scale of pay for class 3 and class 4 shall be paid wages at par with the state government rules. Then 15-1090, a further resolution was passed by the executive committee clearly indicating
that the decision in Annexure 6 was under coercion and the signatures therein was to avoid the situation on the spot when the management was out and force was adopted. The said resolution therefore was recalled. 14,391, the opposite part number 1 and 3 others were proceeded with a disciplinary proceeding and were removed from service. 2894, writ petition challenging the said determination being OJC 221792 was dismissed. 13,494, in the meantime, state government referred the dispute to Labour Court for adjudication under Section 10 and 12(5) of the Industrial Disputes Act, and this was registered as ID 16 of 94. 7/11/94, Labour Court held that there is no dispute and dismissed the reference. 28/12/94, the dismissal was published in the Gazette. 17/3/97, the workmen have filed a petition before the Labour Court to set aside the award. The said application was allowed on 27/9/97. Petitioner has filed OJC 14119 of 98 against the order dated 27.
So what is the amount in the first matter? What is the amount in the second matter?
38,000 odd.
38,000 is the differential payment. The point is like this matter.
And
Under
the second matter?
Second matter, Your Lordship, which my learned senior is referring to in the date chat clause number 9, serial number 9 and 10, the learned Labour Court has allowed a prayer and set aside the termination, which was the subject matter challenge in the writ petition, which are dismissed on the non-compliance of 17B, which is challenge in writ appeal. In the second matter, Your Lordship, may kindly see.
No. Second matter is also the same person or
same person. And second matter, interestingly,
termination.
Second matter, 4 persons are the opposite party respondents. In respect of respond number 2, they have already implemented and back wages has been paid and he has been reinstated.
No, in the first matter, there's only one person.
My lord, only one person.
And the second matter, there are 4.
4 persons.
I see.
I am appearing only for OP number 1.
I see. So in the first matter, the amount involved is only 38,000.
38,339.
Sir, you must have spent more on this litigation, I think.
Not that way, Madam. What has happened? You will also see in the background. Employees come and gherav the management and take an resolution. And that was recalled immediately. On 33C2, the point which I am trying to place before our lordships is admitted this is in the nature of execution and admitted dues will be paid. But here what he is saying that in future the state government, as per the state government rules, this has to be revised. And since that was not revised, and how can he claim under 33C2 saying that revised scale should be given? That is the point, madam. And that application was also filed after 7 years.
Anyway, yes, sir. Yes, sir. Proceed.
Therefore, my submission before your last, this I think I have placed the entire. Then in the meantime, my lord, on 19/3/98, ID 16/94, which was restored at the instance of workman, was posted to 31/3/98 for ex parte award, and the award was passed on 31/3/98. But before its communication, petitioner moved to recall the order dated 19/3/98. The application was rejected and the impugned order. That is other facts. Now, my submission before the lordships will be that under section 33C2, if your lordships will turn to the application itself, Annexure 1.
Yes.
He has claimed saying that had this rules of the rules of the government were implemented, then these are the amounts which I would be entitled.
Yes.
My submission before your lordships will be section 33C2 is in the nature of an execution proceeding, and if some due is there admitted, and definitely it will be executed. if the wages are, he was getting consolidated pay of 300 rupees per month. His claim is that in future, the state government, as per the state government rules, the wages will be amended. So before that amendments were there, he could not have claimed under 33C2.
Yes.
If there is already a due, certainly it will be executed, my lord.
Yes.
Your Lordship,
One minute. Yes.
The court under exercising the power under section 33C2 cannot decide whether he is entitled to those dues or. It is only on the basis of admitted dues he can be directed to pay.
Yes.
So in that view of the matter, my lord, the impugned order under Annexure 3 cannot be sustained so far as this writ petition is concerned, because his claim is from 86 to 91 and it was made in 97.
All right. The second writ appeal, what do you have to say?
Mr. Samantra will be.
This have to only short question is, Lords. There we prayed that, Lords, let the opposite parties, Lords, file an affidavit showing their, Lords, non-engagement elsewhere, Lords. And they never filed it. And the Honorable Court, Lords, Honorable Single Judge directed us to make payment, Lords. In spite of our filing, Lords, several miscases, that let them file an affidavit, Lords, which is required, mandated under 17B with regard to, Lords, non-engagement, Lords. Even till that also not filed, Lords. Let them file it, we will give it, Lords. Because we have got evidence that they are engaged, Lords, and we have filed an application also there also, Lords. Lords, only I will pray, let the writ appeal be pending, let them file a, Lords, affidavit showing that they are
one of these four you've already reinstated is a.
Yes, we have reinstated him, Lords.
How? He also did not file that certificate.
No, he came back, Lords. He said that the person to direction of this, Lords, because he doesn't want to proceed with the writ application, and he got fresh engagement, Lords.
Sorry?
The, Lords, other person, Dakwa, Lords, he himself, Lords, made an application to be re-engaged in the organization, and he was given Lords, re-engagement. And he was paid salary, so he did not want to, Lords, we have deleted him from the, Lords, cost title.
So you're prepared to re-engage them then?
Yes, Lord, he was re-engaged. That is
no. If these three people also come and they ask to be re-engaged, you will re-engage them.
We offered them, Lords. We offered them re-engagement. They did not come forward, Lords.
Okay. Yes.
Even today, Lords, if they file an affidavit saying that they are not gainfully employed since the date of Lords termination, we are prepared to pay, Lords. I have given an affidavit, Lordship. Your Lordship, may kindly see internal page 6 of the affidavit.
No, but the single judge notes that they've already filed such affidavit earlier.
No, they had filed in 1999, Lords.
Yes.
And they were paid, Lords, as per the order of the tribunal. But subsequently, after their engagement, Lords, they did not file. When we offered them engagement, Lords, they did not turn up for engagement and did not file also affidavit, Lords.
No, but have you said, because the order says, just read the order, impugned order of the Learned Single Judge, 22nd April 2013.
It was page 11, third paragraph, Lords. On perusal record appears that on 25 to 1999, this court, while issuing notice to the opposite, directed petitioner to comply for compliance of section 117B of the Industrial Disputes Act. Thereafter, the petitioner filed miscase number 807/2007 for appropriate order, stating that the copy opposite party number 2, Taricharan, has been engaged as class 4 employee in the establishment of the petitioner since 2007. Accordingly, this court, by order dated 18/4/13, directed the OP number 2 is not entitled to relief under 17B of the Act as he has engaged as class 4 employee in the establishment. Then the petitioner thereafter filed miscase number 511/2007 for modification of the order dated 25 to 99. This court, by order dated 22/4/2013, dismissed the said application, directing the petitioner to comply with section 17B of the Act from 2007 within a period of 10 days. Thereafter, the petitioner filed miscase number
123 of 2000, we pray to direct the OP number 2 to receive the wages in terms of filing an affidavit. That affidavit they are not willing to
You
give.
can't insist at that stage, sir. Very strange. After you are clearly asked to pay 17B by this court,
no,
you can't now at the stage of paying saying now you better file an affidavit.
No, because 17B says we will pay, even court but they have to file an affidavit saying
all
that
those arguments were negative in the order dated 22nd April. Those arguments are negative, then you were asked to pay the 17B wages. You can't now at the stage of again making 17B insist on a new condition like this.
No, not a new condition, Lord.
No, sir. Whatever you have to say at the stage of the court having passed the order dated 22nd April. You have to only implement that order.
Yes. Since 1999 till 2007, it was complied with.
Yes.
In 2007, we came to know that they've been gainfully employed. We filed an affidavit.
Unless this court permitted you to insist on such an affidavit before complying with 17B, you cannot on your own say, now to comply with the court's order, you better file an affidavit.
Because affidavit.
This court is very clear. It says this court directs the petitioner to comply with 17B.
Yes, Lord.
Very categorical.
Since 99.
You did not challenge this 22nd April 2013 order.
No, we never challenged, Lord. Till 2007, we complied.
No, sir. 22nd April 2013 order. Have you challenged it?
No, that was in this case. Thereafter, he has the Honorable Singh.
I'm asking you a question, you're answering something else.
I'm not.
You have not challenged that order.
Yes, no.
That order has a clear mandamus to you saying you should pay 17B.
Right, Lord. And thereafter, I filed another miscase, Lord.
You can go on filing, sir. You have a capacity to litigate, so you'll go on filing miscases.
Not that way.
No, that is the fact of the matter, sir. See, hard truth in labor disputes is the management has a greater litigating capacity than the workman.
No,
so the management can keep on coming back to the court with fresh applications.
Because we offered them engagement, they did not agree.
No.
And we paid them 17B.
You are making it conditional. The problem is you're making it conditional, leaving them no choice.
No, but we offered, we offered them engagement.
Yes. Saying that you forego everything else, then you will get fresh re-engagement. That is your offer. That person will forego his 17B, forego his whatever is gained. He'll get a fresh re-engagement as if he's coming today to work with you for the first time.
Till 2007, 17B was complied with. Till 2007.
So these are all not acts of charity. All right.
Right.
This is statutory right. He has to claim 17B. He's claimed it.
Yes, Lord. There is no dispute to that.
Yes.
Only thing is that they should file an affidavit that they are not gainfully employed for
all that stage is over, sir. You argued that it was considered. The court passed an order on 22nd April.
No, that is why I'm in appeal saying that this order is not.
No, you have not challenged that order, sir. No, 22nd April, you have not challenged.
This case order I have not challenged, but I have challenged the final order saying that dismissing my bills for non-compliance.
Nothing in this, sir. There's nothing in this. Neither matter there is anything. Both writ petition is dismissed, writ appeal is dismissed. We'll pass the detailed orders.
And I've already given an affidavit in the second case.
All right.
Stating that until 2017, the Labour Court has given them notices to obtain to comply the order.
All right.
Supplementary list item number 8.
May I please, Your Lordship?
Yes.
My Lord, can you see the order dated 17/5/2022?
Yes.
Last occasion, Your Lordship directed to the state government to take instruction regarding this matter. My Lord, what has happened, my Lord? Pursuant to the advertisement dated 23/9/2002, I applied for the post of the constable. My Lord, kindly see the advertisement. First, Your Lordship, kindly see the advertisement page.
Are you for opposite party number 4?
No, my Lord, I am for the petition.
No. Who's for opposite party number 4?
No, as per Your Lordship direction, I have given the notice by.
Has he been served?
Yes, my Lord, already through the SP. Your Lordship direct to the SP.
Undelivered and returned, sir.
No, last occasion, my Lord's friend saying that SP has already served the notice. My Lord, can you see the order?
Not already been served. Right. You're right, sir. You're right.
My Lord.
17 fines total. Right, right. Yes. Carry on, carry on.
My lord, kindly see the Annex 1, page 11. There is an advertisement.
They have not filed that affidavit indicating merit list of ACBC. My lord, there is an order of 17th May. Do you have that order?
I have that order.
Just read the 17th May order.
No, my lord, I'm sorry, I don't have that. I'm so sorry.
Just show him the order, 17th May.
So sorry.
You have filed the affidavit?
No, my lord.
No, we have not filed.
If you don't have the order, how will you comply with it?
This is not an affidavit, my lord. I'm so sorry.
Counsel for the state seeks and is granted a final opportunity to comply with the order dated 17th May 2022 within 2 weeks. List on. October.
Supplementary list item number 9.
Well, it is the last chance.
May it
Item
please,
nine.
Milords. Milords, I have received a counter from opposite party number 3, Milords. May I be permitted to file a rejoinder by opposite party number 3?
All right. Rejoinder to the counter affidavit of opposite party number 3 be filed for the next day, 10th October.
Great. Supplementary list item number 10.
Kindly dispose of the matter in view of the
Compliance
show cause
affidavit.
affidavit.
In view of the counsel for the petitioner states that the petition may be disposed of in view of the show cause affidavit. Right.
Supplementary list item number 11.
Disposed of as such.
But item 11 pass over, my lord.
All right.
Supplementary list item number 12.
In this case, my lord has directed BMC to I have already appeared today, my lord. We have entered appearance. His allegation is as regards to drainage system. Drainage system, water storage board, Odisha State Storage Board, what code they will do. And what we have understood that they are going to do the work and irrigation department is there. The BMC here.
File an affidavit, sir.
I will file the affidavit.
Counsel appearing for the BMC, Learned Senior Counsel, Mr. Mohanty, Learned Senior Counsel for the BMC, states that
number
he will file an affidavit indicating the proposed steps to be taken. This affidavit will be filed within 4 weeks. Rejoinder there to Philly for the next date, 22nd November.
22nd October.
November, sir.
Item 13.
You call it out and
Supplementary list item number 13.
This matter pursuant to Lordship's direction dated, I filed an affidavit.
you want some more time. You say you will carry out those inspections in September.
No, complete it. We have already started. Crack teams have been moving, Milords. Even yesterday, 2 crack teams under the Milords leadership, Additional Secretary, Milords Periphery and Milords Medical College, they had also gone. One report I have submitted pursuant to Lordship direction, and that will be completed by Milords September, Milords.
All right. See, unfortunately, there is a reference at 2 p.m. today, and therefore this matter is unable to be taken up. Learned Mr. Samantrai, Learned Counsel appearing for the government, states the crack teams are already moving to different locations, and he expects that by the end of September, the exercise as directed by this court will be completed. List on 11th October.
Yeah.
11th October.
Okay.
You'll have to inform Mr.
Mr.
Chittaranjan Mohanty.
I will inform you. Supplementary list item number 14.
May please, Your Lordship. May I allow to, on behalf of Mr. Loyal Chandra Mishra. My Lord, the conducting counsel is supposed to argue this matter. Unfortunately, the sad demise of his colleague.
Or counsel for the petitioner is stated to be in some difficulty today. List on 28 November.
Supplementary list item number 15.
Obliged, Your Lordship.
My Lord, may I please, Your Lordship? I'm on BC, my Lord. My Lord, this is a matter relating to the illegal declaration of result of the petitioner.
We'll have done some other days. Today there's
My
a
Lord,
reference.
the petitioner
We'll have it on some other day. There is a reference today at 2 o'clock.
as my Lord will.
As there is a reference today at 2 o'clock. The matter can't be taken up. List on 6 December.
My Lord, as my Lord will.
Supplementary list item number 16.
Item 16, my lords. I have tried to simplify this entire case in just one page. These are all, these had come up, my lords, earlier, which basically says that there should not be any reservations in promotions.
I know, sir, this is not such a simple case.
My lords may see those
I know.
8 points.
May I pray one thing? May I pray that the petitioner implicates the law department of the state?
No, my lords. Why should the law department be implicated?
But ultimately, the state has to defend the virus of those rules.
My lord, may kindly hear me for a moment.
State is one. Any department can defend it.
My lord, so far as Orissa is concerned, the key judgment would be Pravakar Malik, where before the Supreme Court, they have themselves said that this exercise in terms of M. Nagraj hasn't been done. So after that, nothing remains so far as Orissa is concerned. They are still continuing with the outdated law of 1975. Post 75, we have had Indra Shawni in 1993. Then Nagraj came in 2006. So we are still in that 75 era, my lords. So that exercise hasn't been done, and those admissions have been recorded before the Supreme Court in Prabhakar Malik's case. So that one judgment actually crystallizes the issue. So after that, I think
So you are saying that there cannot be reservations?
There cannot be any reservations in promotions unless you follow the exercise as mandated in the case of
similar to those reservation in panchayat bodies.
But that's a separate issue.
I know.
That's governed by a separate set of judgments. Here, these are the judgments. So there are basically 3 main judgments. Nagraj, then Jarnail Singh, which recently came about, where they took down one of the conditions. And after that, we have had judgments of Justice Nageshwar Rao and all I have given, my lords. So Pravakar Malik, if my lords would see that judgment.
No, but even to read those judgments will take half an hour.
Yes, it may not be possible today because of
We have so many references. That's why our board is unable to be arranged.
Let this be kept on record. All that I pray, my lords, is a short date because this needs to be resolved. So far as my client is concerned, he's also last date was his order was vacated.
I am also supporting Mr. Misra here.
I know.
Second
But
case,
somebody else must be opposing you people.
Somebody is there. Mr. Das is there.
Look, in fact, that I only rely on that one judgment of Pravakar Malik. That crystallizes the issue so far as Orissa is concerned. This note may be kept on record.
Yes.
I pray for a short date, my lords.
The note has been submitted on behalf of the petitioner, which is kept on record. On account of there being a reference today at 2 p.m., the court is not in a position to take up this matter today. List on. You take a chance on 11th October.
That will be fine. 11th October.
11th October.
August, September, October.
All right.
Item 16 and 17.
17 also.
Yeah, same. Correct.
The second matter is also
right.
Supplementary list item number 18.
18, my lord, I have already filed a requisite. My lord, 18, I have already filed the requisite.
AD is not back from sole respondent, but it's been served. It's been served. All right. You say admit the following questions. You say despite service of notice, none appears for the respondent. Admit the following questions are framed for consideration. A and B. A and B is the same thing, sir.
Same, Milord.
Oh, A is enough. Just A. Listed. Right.
Supplementary list item number 19.
From 19, my lord. Counter was filed by OP number 2. I am to file a rejoinder. And
Rejoinder be filed for the next date, 12th December.
may I pray may be taken up in month of October if convenient to your lordship?
No, sir, because already holidays in October. That's why.
Supplementary list item 20.
My lord, I'm busy. The counter has not been filed yet, my lord.
Yes.
My lord, I'll kindly some more time for the counter.
All right. Last opportunity to file counter within 4 weeks. Rejoinder for the next date. 7th December.
Supplementary list item 21.
Well, in item 21, my name has not come, but my lord, there are batch of cases. About 50 writ petitions were there. And they were posted to 22nd of this month before Honorable Justice S.K. Misro.
All right.
Because they are single matters.
All right.
But this should also go there.
All right. Mr. S.S. Rao's name be shown in the cause list. He points out that this is a single judge matters. Another huge a batch of such similar matters is already listed before Justice S.K. Mishra on 22nd August 2022. List this petition also before the same bench on that date.
Supplementary list item 22.
22 minutes, ma'am. 22 minutes?
Yes, please.
Milords, may permit me to file a rejoinder, Milords.
All right. Rejoinder filed for the state.
Milords, the interim orders that passed earlier, Milords, the appeal is not being disposed of, Milords.
All right.
Since
Appeal will be filed will be disposed within 4 months.
Milords may direct till then no course of action.
All right. You say, having heard learned counsel of the parties and considering that the prayer is a limited one, court directs that the appeal filed by the petitioner be disposed of by the CIT appeals.
Yes, Milords. NFAC now, Milords. The National Faceless Appeal Center.
Bracket NFAC. Within a period of 4 months from the date of receipt of the certified copy of this order. Till such time, the interim order passed by this court on 4th January 2022 will continue. A copy of this order be sent to the NFAC forthwith. The petition is disposed of here.
I'm great. Obliged.
Supplementary list item 23.
23 mileage. I pray for next week mileage. Mr. Mohanty is on accommodation mileage.
Counsel, the petitioner has stated been some difficulty today, just on 14 December.
Supplementary list item 24.
May I please, Lordship? Lordship, kindly grant some time for filing of rejoinder, Lordship.
All right, rejoinder be filed for the next date. Interim order to continue, 14 December.
Lordship.
Supplementary list item 25.
25, I may claim not do is time to allow file counter.
My interim order may continue. Counter be filed as a last opportunity within 4 weeks. Rejoinder for the next date. Interim order to continue, 14 December.
Supplementary list item 26.
Interim order to continue. Item 26, we received the instruction from the Ministry of Ayush, my lord. For each time we given the file counter.
Mr. Padi states that he's just received instructions. He seeks and is granted 4 weeks to file reply. Rejoinder for the next date.
Is Babita Sahu name reflect along with?
All right. List on 7 December.
Supplementary list item 27.
I may pardon to submit me, Lord. My grievance is a construction of a foot over bridge in Chhatrapur main station, my lord. That they have taken instruction, my lord, last date, my lord, directed to.
Yes, Mr. Padi, what's the position?
People are suffering like anything, say, my
Mr. Padi.
Some time may be given. Just I've gone through it. Sometimes.
The party seeks and wants more time for instructions. Some orders not there.
Date maybe.
Mr. Party appearing for the railways seeks
Yes.
time for instructions. 17th October.
Supplementary list item 28.
BK party maybe appear along BK.
All right. All right.
28 lordship counter file or copy not solved lordship.
Copy of the counter affidavit will be served on counsel petitioner during the course of the day, rejoined up to the next date. 5th December.
Supplementary list item 29. Item 29, my lords. Your lordship, my lords, by order dated 15/7/2015, have admitted 3 reformulated questions, my lords. Because these questions are substantially covered by one judgment of your lordships, so far as question number 3 is concerned, and one is covered by your Honorable Apex Court judgment in Harishankar Rastogi's case. But what has happened? Initially, there was assessment, and it was reduced in first appeal. And the London Tribunal will revive the assessment, even though London Tribunal allowed the substantive prior to the petitioner. Because if your lordship will see, my lords may kindly see page 15, my lords. Page 15, just 2-3 lines, I am concerned about my lords. Page 15, my lords. Because your lordship will find shortage. Basically, the issue related to shortage, my lords. Paddy, boiled rice, then raw rice. Substantially 3 issues, my lords.
Right.
Then these discrepancies, you have 167 quintal, 110 boiled rice, and raw rice 58. Then my lords may kindly turn to page 22. By a reasoning order, Assistant Commissioner has allowed these 2 substantial issues, 167 quintals. My lords may kindly see first paragraph at the end. Therefore, the explanation offered by the appellant found convincing, and charge of suppression reported is not established. 110 quintals boiled rice. Next paragraph, suppression is alleged by STO is not established. Then 58 is stands, my lords. So now you also may kindly turn to page 28, Tribunal's order. Page 28. Regarding the shortage of 110 boiled rice, the stand is that the same has been sold to FCI Pulwani. This is the STO didn't accept. No doubt supply of SCI was not deducted from the stock account. The fact could have been verified from SCI Pulwani. In absence of verification, since the despatch supported by Chalan and Webel, which are checked by RMC Hijilikot and also at the intersection point of Commercial Tax Department, it cannot be concluded that dealer has suppressed sale of fund. So it is accepted by the tribunal. Despite of the fact that tribunal accepts the 110 quintals of boiled rice, but it revives at the end, my lords may kindly see, it revives the entire assessment, whole demand. This is one. And here, I have today given to your lordship, I have filed cross objection in this case. And the law is, Honorable Apex Court said, because the cross objection has all the trappings of an appeal, my lords. But it is not that one can ignore while disposing appeal, cross objection and proceed to dispose appeal. Honorable Apex Court said cross objection still survives even if appeal is disposed of.
This is that Harishankar Rastogi.
My lords. So my humble submission is that, so far as cross objection concerned, that could have been taken note of. Now 11 long 12 years have been passed. So therefore, and so far as this shortage aspect, substantial issue is concerned, that is covered by lordships. Radhakesh of Samil's judgment, paragraph 10 covers the entire issue. Your lordship said
the only question that survives.
Exactly. So therefore, para 10 covers the entire issue. I have given to lordship judgment of Radhakesh.
Correct.
My lords.
Yes, Mr. Mishra.
Your lordship.
Suppression. This is also suppression of stock.
Your lordship, that can be the only question, because so far as the enhancement is concerned, so far as the enhancement made by the tribunal, the earlier 2 questions which has been framed in the in the revision petition, your lordship, that those may not be accepted. Why, your lordship? Because here
no, they are only going for the reformulated.
Now the reform, those 2 are not there now. 15/7/2015 order.
We passed a detailed order. No?
Yes.
Your lordship, I'm sorry, I have not gone.
19th May.
Your lordship.
2022.
Your lordship, that reformulated questions are not in my order sheet. I'm sorry, your lordship, because I've been prepared the case on the basis of the questions stated in the revision petition, your lordship. Because here the assessment has been completed and the first appeal order that has been reduced and state has gone in appeal, and the appeal has been state appeal has been allowed by confirming the assessment order. So there is no enhancement. There is no enhancement made by the learned tribunal, Your Lordship.
No, but here just see the 15/7/2015. No,
Yes, 15/7 or 15.
the three questions. 15/7/2015. You don't have that.
Yeah, I'm sorry, Your Lordship. My order.
Just show him that at least.
Your Lordship, please, yes. Your Lordship.
But substantially, Your Lordship have dealt in
Radhakesha.
minors. Para 10 deals with this.
Here, Your Lordship, no enhancement. Here, Your Lordship may kindly go through that judgment, Your Lordship, which has been passed by Your Lordship. There was enhancement. Here, there is no enhancement, Your Lordship, for what I think.
A restoration amounts to enhancement.
It is basing on the state of Your Lordship. So far as this judgment also and Upar Udyog, Your Lordship has passed another judgment also.
No, 1 minute. STO determines something. ACST reduces it. Then the tribunal restores a STO.
Your Lordship, on departments of it. On department of
correct.
Your Lordship.
Correct.
So there is no enhancement, Your Lordship, because Your Lordship, state agreed by the order passed by the First Appellate Authority has filed the appeal before the tribunal. And tribunal, after hearing both the parties, has allowed the state appeal by restoring the assessment order, by confirming the assessment order. So there is no enhancement, Your Lordship.
Not allowed. I have read one paragraph where tribunal accepted the stand of the petitioner, saying that there is no suppression. So far as boiled rice of 110 quintals is concerned.
Your Lordship, what tribunal has said, therefore the assessment order of the learned STO for the assessment so-and-so raising demand of rupees 72,000 is upheld. And the impugned order is found.
No, despite finding there's no suppression.
Yes.
That's the point.
Yes.
Your Lordship may kindly turn to page 29, the last paragraph. The dealer has suppressed purchase of rupees 19 quintal of paddy, approximately 10,450 from 10/3/2014 What is most glaring is that 10/3/2002, there was a shortage of 58.22 quintal of raw rice in stock, but on 14th March, there was excess stock of 3.16 raw rice. But account reveals no milling paddy during those 4 days. In this respect, the only conclusion that can be drawn is the dealer has suppressed purchase of nearly 100 quintal of paddy, gets nearly 62 quintal of raw rice, sold the marketing goods of shortage and excess boiled rice. We estimate the purchase value of paddy at rupees 55,000 and sale value 60 to 60,000. Now together will come 1,15,000 in the result. The estimated detected suppression comes to rupees 2,61,000. The occasional suppression has computed above a pattern. With this suppression, the suppression for the whole year as estimated by the Lone STO in the assessment order at rupees 15 lakhs so is accepted as it is reasonable and meet the ends of justice. Your Lordship, they have not accepted the contention of the petitioner, Your Lordship. The law and tribunal, what my law and senior submits, that is the submission of the and the consideration by the First Appellate Authority.
No, 110 quintal accepted by tribunal.
Your Lordship,
page 28, last paragraph. Accepted by tribunal.
Basing on that
no suppression.
No.
And the rest, what my friend argues, is covered by Radhakesha of Samils. No cell. There is no evidence of any cell. Dealt in thread by Your Lordship Willows. 110 accepted by tribunal. It is not that contention. It's a finding of tribunal. There is no suppression in respect to 110 quintal of boiled rice. 167 they have confirmed. Yes. 67 again, that is my submission is Radhakesha. That's the only issue, shortage. No evidence of cell. And what ultimately survives is this CO. Otherwise, these are all covered millers. CO is also a great lapse, according to Honorable Apex Court. I'm not on that because on this, that will again go back and after
no
long
need to
years,
answer that. Yes.
that will not serve any purpose, my lords.
Your Lordship, please, it is only amount of 72,000.
Oh.
Your Lordship, only 72,000 and that has been reduced to 20,000 and again 72,000. Only that is the issue.
That is the issue.
All right. Okay, question number 1 is answered in favor of the SSC, dealer, and against the department. Questions 2 and 3 do not arise for, have become academic and are disposed of.
Supplementary list item. Item 30. May I please, sir? Well, I have been instructed to appear in this case
For the state.
opposite parties. And I have been.
No, you are for NALCO.
NALCO. File has been transferred this evening.
Your Lordship, this case is already argued that interstate and intrastate, Your Lordship, the person sale of DEPB and covered by that OFTC judgment.
No, my lord, that judgment, let me, in the Supreme Court.
Let me argue.
No, that judgment has been referred in the another subsequent judgment of this honorable court. That state has gone to the Supreme Court and it has been upheld in favor of that. I'll place that order.
Yes. Let me start with your permission.
There's a reference, sir.
Any other date, my lord.
September.
Supplementary list passed or matter item number 11.
May I please? This is almost a covered matter, my lord, by the Honorable Apex Court. My lord, here the question is whether the petitioner who was working as a lecturer under the Utkal University is liable for tax. My lord,
we'll have it on some other day, sir. November 23rd November.
Well, I'm filing a written note. The judgment was reserved on last week.